Good afternoon and welcome to the Appellate Division, First Department. We have more than 7.5 hours of argument time requested, so I will give you my usual spiel. We are familiar with the record, your briefs, usually more than you wish we were. So please ask for the time you absolutely need, not the time that you want, understanding that the clock is for you, not for the court. So if my colleagues have additional questions beyond the light, I let the time roll, okay? And I can assure you that your colleagues at the end of the calendar will be most appreciative of this request. All right, People versus Malachi Colon.
Good afternoon, Your Honor. 6 minutes for the main argument, 1 minute for rebuttal for Appellant Malachi Colon.
Okay. 6 and 1 and 6. I'm gonna mess up this last name, so forgive me in advance. Katrai Farr, sorry, versus New York Presbyterian.
Your Honor, 6 minutes for appellant and 2 for rebuttal, please.
Okay. All right, 6 and 2 and 7. Thank you, ladies. City of New York versus Crest Housing Company.
Good afternoon, Your Honor. Appellant's request 6 and 1, please.
Okay. 6 and 1 and 4. Lent versus City of New York. Oh, I like that. Go ahead. 2 and 1 and 3. Bermeo versus Master Plumbing. Okay.
Master Plumbing, 4 and 1.
Do you have a cross appeal?
Yeah, we do have a cross.
Okay. 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 4 and 2, 4 and 1, 3 and 2. People versus Sean Santiful. Submitted. Matter of estate of Robert J. Giardanella. Okay. Okay. 5 and 3 and 5. Lilly versus State of New York.
Good afternoon. I would request on behalf of the appellant 6 minutes for the principal argument, 2 minutes for rebuttal.
Okay. All right, let's do 5 and 2 and 4.
Very well.
Catan versus Roner. I don't think you have anyone to rebut. Oh, okay. All right, 5 and 1 and 5. I don't think it requires all that time, but who knows? Maybe my colleagues will ask questions beyond the light. MPAL Technology versus Amazon.com. Submitted. Hubschman versus 1010 Tenants.
Appellant request 6 minutes and 2 minutes for rebuttal.
Okay. You have a cross appeal? Okay, 6 and 2 and 5. People versus Devon Pleasant. We're hearing both of the appeals together, so give me one total time.
Appellant request 5 and 2.
Okay. 5 and 2 and 5. Solil Chartered Bank versus Breton Equity Company. Submitted. Zyobro versus Milan House.
Good afternoon, Your Honor. The appellant 6 and 2.
Okay.
1 and 4.
All right. 5 and 2 and 4. Gant versus City of New York. You have a cross appeal? Do you have a cross appeal? Then you don't get rebuttal time. So how much time would you like? Okay. 5 and 1 and 5. Rosario versus CC Controlled Combustion. We'll take that. Have a seat until we finish the calendar, though. Thank you, gentlemen. People versus Joshua Bosch. Okay. 4 and 2 and 4. First case on the calendar, People versus Malachi Colon. You may proceed.
Thank you, Your Honor. May it please the court, my name's Arthur Hopkirk. I represent Malachi Colon. As the prosecutor recognized at sentencing, this tragedy was the result of Mr. Colon losing his temper during an argument. The prosecution on appeal fails to adequately acknowledge both the reasons the 21-year-old Mr. Colon had difficulties with impulse control and controlling his anger, and why those problems are much less likely to recur when an older Mr. Colon is released from prison. There are, as we discuss in our brief, general issues relating to the continuing development of the parts of the brain governing impulse control up until about the age of 25. And then there are issues specific to Mr. Colon. For example, Mr. Colon, at an unusually early age of 7, was diagnosed with bipolar disorder and oppositional defiant disorder. As I say, that's a pretty young age for that. And the oppositional defiant disorder, one of the...
That's not so unusual, by the way.
It is not as unusual as the
Not-
bipolar,
it
but...
is right up there with ADHD diagnosis. We have a lot of children in our society with oppositional defiance disorder, a lot of them.
Yeah, but the combined diagnoses are unusual. And one of the things with that disorder is also further difficulties beyond the average 21-year-old.
He seemed rather premeditated and thought through at the time of the commission of the crime. You know, he seeks to blame the shooting on Snake Eyes. You know,
I wouldn't suggest that is an example of premeditation, Your Honor. First of all, actually, the oppositional defiant disorder often involves as one of its symptoms blaming others. And secondly, it was a very poorly thought out sort of thing, showing that he really, that was not really a very serious attempt to cast blame on others in terms of its credibility.
Counsel, let's analyze this from why we're here. He agreed to the plea. The court was very careful and sensitive to his alleged cognitive deficits. He walked him through each Boykin right very carefully, and the transcript bears that out. He had 2 attorneys representing him during the course of the plea, so he was fully protected in terms of representation. In fact, there was a discussion where the court acknowledged that a certain suppression ruling went in his favor. A lot of positive checks here. We're talking about a very serious crime of murder where he ultimately pled to manslaughter.
So I agree that the court was well-intentioned in its efforts to discuss various things with the defendant, Mr. Colon, but nonetheless, there are certain things, as we point out in our brief, that really were not covered on the face of the record as this court's require for a valid waiver of the right to appeal.
We have to assess it on a totality of the circumstances. So tell me how, between the colloquy and the written waiver, all of the required issues of disclosure were not covered, and that the defendant did not provide a knowing and intelligent waiver in light of the totality of the circumstances.
Okay, well, the totality of the circumstances, of course, include his age, his lack of experience with the criminal legal system before, his background with his mental health issues, and also specifically, although certain things are in the written waiver, that weren't gone over in the oral colloquy. Those
And no case says that is required, right? The judge, there is no particular litany that the judge has to engage in. It is a totality of the circumstances,
Yes,
right?
and-
So tell me, what was missing?
the although Your Honor is obviously correct that there is no required litany, it's nonetheless what is required depends somewhat on the background and the age and so forth of the accused. And under the facts of this case, for example, there was not any effort to confirm with my client, that any but one of the things which remains after the waiver of the right to appeal. So there wasn't any confirmation. People with cognitive difficulties may think they understand things, but they don't actually, and so it's very important to actually ask
As my colleague
specifically.
alluded to earlier, okay? Notwithstanding his cognitive difficulties, he had enough cognitive awareness to try to blame someone else for shooting his girlfriend in
It
the head.
doesn't take very much.
Okay?
That doesn't.
You'll have time on rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. I'll start by just briefly addressing that this sentence was, of course, proper. 20 years certainly befits a crime where the defendant here point blank shot a young mother in the forehead, and later made a pretty damaging statement about that, as Your Honor alluded to earlier. And this is also appropriate in light of the defendant's serious history of domestic violence against a former girlfriend, and in light of the fact that he tried to blame this murder on someone else. In addition, the defendant validly waived his right to appeal. I am happy to go over that, but in brief, the court fulfilled all of the core concerns that this court has put forth about appellate waivers. It made sure that the defendant knew this was not something he was automatically forfeiting. It told him—
Wasn't there something in the record where the court painstakingly gave him an example of how he could appeal an illegal sentence?
Yes.
He discussed highs and lows, below maximum, above maximum, and added there are other issues. In other words, he was walking the defendant very carefully through what his rights were.
Yes.
In fact, in discussing the issue of appellate waiver, part of the language that the judge used was, and your attorney would be able to raise issues with regard to, and he went on to discuss all the various issues that could have been raised through his counsel on appeal.
I think the court took great care to make sure that the defendant understood what was happening here. I think you can see that at the very beginning of the colloquy, where the court says, it is so important that you understand everything that's happening here. I understand that you have some comprehension issues. I'm going to speak slowly. If you need me to speak more slowly, please let me know. If you have questions, please let me know. I'm happy to elaborate.
And if I recall correctly, on at least one occasion, the judge said something that caused the defendant to ask a question.
That's correct, Your Honor. So in short, the court fulfilled all core concerns when conducting a waiver colloquy. The waiver was absolutely valid, and in any event, the sentence befitted the crime. Thank you.
Just briefly, Your Honor. One thing which is notable here is that the colloquy was quite different than what the model colloquy is. One thing that was left out completely is my client's right to counsel on an appeal at state expense. Somebody with cognitive difficulties hearing they're going to have a right to appeal, but if they don't know that they're going to have an attorney to help them with that, they may think—
You mean that even after the waiver, that he still can get an attorney even after the waiver? Is that what you mean?
Yes, that,
But haven't we held that that's not a basis to find the waiver invalid?
well, there have been, I'm not sure whether any cases with somebody with the cognitive difficulties of my client, because maybe some people would understand they get an
Defendants who
attorney,
waive
but
that with serious mental health issues, with serious drug dependency issues, and a combination of the two. So
other thing which was not really in accord with the model colloquy is that rather than talking about how he could raise the voluntariness of the plea, it says validity of the plea and voluntariness of the waiver. And somebody who's a layperson might well be mistakenly believing that challenging the validity of the plea could go to whether you actually were guilty and whether you could challenge that on appeal. So for that reason also, we would suggest that the waiver is not knowing, intelligent, and voluntary.
thank you so much. Katir Afar versus New York Presbyterian. How do you say the name? Katir Afar. Thank you so much. You may proceed, counsel.
Thank you, Your Honor. May it please the court, I'm Barbara Goldberg. I represent the defendant, New York Presbyterian Hospital. As the court is aware, the Supreme Court found that the hospital established its prima facie entitlement to summary judgment. Plaintiff doesn't concede that. So the only issue for this court to decide is whether plaintiff succeeded in raising issues of fact as to the medical malpractice cause of action. And I submit that it did not. As we've explained in detail in our brief, plaintiff's two experts didn't even acknowledge having reviewed the expert affirmation submitted by the hospital's expert, Dr. Kamilar. Dr. Kamilar gave a very detailed opinion as to why he found that there were no departures from the standard of care and the manner in which the decedent was transported from the emergency department to the floor. And he also gave a very, very detailed explanation as to why the decedent did not suffer any cognitive impairment as a result of the alleged respiratory arrest that he suffered, was noted to have suffered shortly after his arrival on the floor.
Your expert seemed to have gone through in more detail than sometimes I've seen exactly what happened on that day and after that day, and did a very comprehensive discussion of the facts as well as of his opinions. So it was pretty comprehensive. When we go to plaintiff's experts, how did they deal with the causation?
They really didn't deal with the causation, Your Honor, because they assumed, Dr. Silverman sort of assumed that there was an insufficient or inadequate ambubagging without going into any detail as to what the standard of care required for ambubagging, and then sort of going with
Is the claim that there should have been a portable ventilator and that wasn't used during the transport?
No, Your Honor, there is no claim that there should have been a portable ventilator, and in fact, I don't think the hospital even had portable ventilators, as Dr. Kamilar pointed out. They're claiming that the ambubagging was somehow inadequate or inefficient or not done in the appropriate manner, but Dr. Silverman, plaintiff's expert, was very, very vague about that. He just sort of assumed that there was insufficient ambubagging, and the other expert, Dr. Engstrom, assumed that there was hypoxia and that caused the injury, despite all of the evidence which Dr. Kamilar went through in detail, which explained that there was no hypoxic.
What was interesting is, and this is unusual, and I pick up on what my colleague raised, Dr. Kamahar actually analyzed deposition transcripts of the executor or
Yes.
son, brother,
The brother, the plaintiff.
in parallel surrogate proceedings in New Jersey.
Yes.
And in fact, in that proceeding, in a deposition, the plaintiff here, who's claiming that there was an anoxic injury in that June date, represented in sworn testimony that the decedent was fully competent in July and August after that June date to make the will changes that he made.
That's absolutely correct, Your Honor.
So he's speaking from two sides of his mouth, so to speak.
Yes, I think that's a very good way of putting it, Your Honor. And just turning briefly to the causation argument, because I see my light is coming on. The only way they tried to establish that there was an injury was that allegedly he wasn't able to use his computer software, which, much like Stephen Hawking, he was able to operate and activate by a blinking rhythm. And they said that he didn't do that as well after the June hospitalization. But it's unequivocal, and his own nurses, Nurse Betty Verwee, who had been with him for literally years, testified readily that she was able to continue communicating with him by blinking after this hospitalization. She talked about a very elaborate blinking system that they developed, including blinking, raising his eyebrows, using an alphabet board that was up in his room. And
In
that
fact, during the treatment at issue, at a certain point, one of his private nurses says he's communicating, he's having difficulty breathing. I mean, he is still communicating with her, even though he is having difficulty breathing.
That's correct, Your Honor. I believe that was, again, Nurse Verwee, and the other nurse who was present, Joyce Sale Linjoko, testified that after the incident, he basically came back to his baseline, and there are numerous references to him returning to his baseline, and in fact, Dr. Maxfield, who was his treating pulmonologist, documented that he fully returned to baseline after this incident. So I submit that plaintiff failed to raise an issue of fact either as to a departure from accepted practice or proximate causation. And if the court doesn't have any further questions for me, I'll reserve my time for rebuttal.
Thank you.
Thank you, Your Honor.
You have 4 seconds left, right in the nick of time.
May it please the court, Cynthia Mateki, on behalf of the respondent here, Your Honor. The issue here is whether there were conclusory, speculative, or anything that was failing to address defendant's assertions. I searched for an absolute requirement that the responding physician's certifications had to say, I read the deposition, or I read the...
We have, our precedent in this department is replete with cases that say that on a medical malpractice case, plaintiff's counsel must rebut the opinions of the defendant's experts. We say that again and again and again.
And I absolutely agree that that is in every case. But the fact that he didn't mention that he didn't rebut them, that he didn't read, that it wasn't in there, there's...
So are you suggesting that there should be an out for plaintiff's experts? If I don't look at the defendant's expert report, then I don't have to opine on it?
Not at all, Your Honor.
Okay, so then how is that failure to respond to the defendant's experts' opinions not fatal to your case?
Your Honor, he did respond. He
He
responded.
did not respond. Did not.
Judge Kelly found that he responded. I cited several.
And that's why we're here. So we get to decide whether we agree with Judge Kelly.
I understand.
And I am saying to you, I saw nothing in your experts' reports that directly contradict the opinions of defendant's expert. Nothing.
It's just not so, Your Honor. The issues in regard to what occurred during the transport were testified to by witnesses who were there.
The doctor focused, I would agree that Dr. Silverman focused on the notes of the various nurses that accompanied the patient and in the ICU. I understand that. but this is something that sticks out that I believe Dr. Silverman should have squarely addressed. The claim by the plaintiff is that there was decompensation, mental decompensation or injury due to an hypoxic event. That's the central claim. And this is what Dr. Kamahar had to say about what transpired, knowing that when the transfer occurred and the patient was already in that bed, then desaturation occurred. The doctor said, the mental status changes due to toxic metabolic encephalopathy was due to the patient's aggressive pneumonia and resulting sepsis, and not due to a hypoxic event caused by not utilizing mechanical ventilation during the transfer. It is important to note that the decedent returned to his baseline level of function, was able to communicate with the nurse through blinking. That, coupled with what I said to your friend earlier about the plaintiff actually acknowledging in sworn testimony that his brother was fully competent after this June event to change his will, et cetera, and that the blinking, and as it deteriorated over time, was due to the ALS, because you do not challenge the dismissal of wrongful death. What I just read to you,
I didn't even
what I just read to, bear with me, counsel, what I just read to you from Dr. Kamalhar's, I think, some 15-some page report versus Dr. Silverman's 7-page report. Did he challenge that opinion? I didn't see that in his report.
He did, Your Honor, in regard to the causation of the respiratory collapse, because he said that the plaintiff was in good shape when he was in the emergency room. He had none of the secretions. He had no indication of sepsis. He had
He had
no...
a double pneumonia. The scans showed cloudiness on both sides of his lungs.
Mild opacities in both sides, yes. We're not disputing that, Your Honor. But his thesis was the fact that Dr. Kamalhar was relying upon the fact that there was a whiteout upon arrival at the floor, and yet that whiteout cleared within hours, and therefore it was not due to either secretions or pneumonia or any of those causes.
Dr. Silverman set forth in his view what the appropriate standard of care was for providing ventilation for a patient in the position of the decedent being transferred from the emergency department to a medical floor?
Yes, constant ambubagging, not intermittent ambubagging. And Your Honor is correct that the pro se complaint indicated the ventilator should have been done, but that was against hospital policy. And that was not pursued in bill of particulars or anything like that. The real issue is, how did he get so wrong in that period between the transport and arriving on the floor? He was diaphoretic, he was cold. It was clear that he had suffered a severe respiratory collapse at that point, and respiratory team needed to be called.
Counsel, can you respond to a forensic evaluation that took place in the probate proceeding where the doctor said, and I'm quoting from A1329 in the record, his own primary doctor, I believe it's Dr. Maxwell, had ample opportunity to bring up the issue of capacity, competence as a family member, and chose never to even mention his mental status in any one of the 68 pages of medical records in the few months of 2013 surrounding the reported anoxia incident. So his own personal physician, who had no dog in the race here, so to speak, found no problem with his competency despite everything that you're alleging here.
Well, the claim put forth by the plaintiff was the diminution of capacity and his ability to use his computer throughout the rest of short months of his life.
Thank you.
I'll just be very brief, Your Honor. I would submit that the reason why the whiteout that was noted in the x-ray taken shortly after the decedent's arrival on the floor was due to the aggressive regimen of suctioning, giving him albuterol, giving him both ambubagging and mechanical ventilation. That's why the whiteout cleared.
And during the period that of this transfer, he was with one or two of his private nurses in addition to someone directly from the hospital. And didn't the nurse testify that had she observed any complications, they would have been documented, but nothing was documented as to any complications during that period of time?
That's absolutely correct, Your Honor.
There
That
were
was
5 people who moved this gentleman from the ER to his room. His 2 private nurses, a respiratory specialist, a nurse, and 1 other individual from the hospital. So there were 5 people moving him from one place to another, correct?
That's correct, Your Honor.
The oxygen problems don't develop until after the transfer, right?
That's correct. It's very clear in the record that the respiratory problem was noted after his arrival on the floor. And again, I think that
And the very reason his brother brought him to the hospital
Right.
was because he was having difficulty breathing.
that's correct, Your Honor.
This was not an uncommon occurrence for this gentleman.
Not in the least, Your Honor.
Thank you.
Thank you, Your Honors.
Thank you. City of New York versus Crest Housing Company, LLC. You may proceed, counsel.
Good afternoon, Your Honors. May it please the court. Alexander Likianos of Holland and Knight for the appellants. There are 2 principles enunciated by the Court of Appeals that are determinative in this matter. Number 1, as the Court of Appeals held in the Vermont teddy bear case, as well as many other cases, a clear, unambiguous commercial lease negotiated by counseled, sophisticated business people must be enforced according to its terms. And the second related principle was handed down by the Court of Appeals in the Barn and Associates case, that a commercial tenant's real estate tax obligation must be governed by the terms of the lease. Application of those principles, I would submit, requires reversal of
Well,
Supreme
here, the declaration at issue said that the defendants were only permitted to calculate additional rent based on the real estate taxes actually paid by defendants.
I'm sorry, what are you referring to, Your Honor?
Isn't that what the declarations,
No, so
that the plaintiff is alleging?
So- So the operative,
Control here?
so the operative provision here, Your Honor, is paragraph 4BD.
Right.
Paragraph 4BD states that the tenant's real estate tax obligation is to be based on the original assessed valuation of the building.
There's additional language, though.
There's-
Isn't there language that says, talks about actually paid by defendants?
So I'll get to that in a moment.
But that's the issue.
Okay.
So I need you to get to
Okay,
that
so
now.
I'll get to that right now, Your Honor.
So that's in the first paragraph B of that section, right?
Right, so paragraph B, so what that is referring to, that's a prerequisite. So before the tenant has to pay its obligations, the landlord has to show proof that it paid its obligations.
Right.
That is simply a condition precedent. That does not override the express language in paragraph 4BD.
Well, the way conditions precedent work is that condition has to be met before we look at anything else. So was that condition met?
It absolutely was met, Your Honor.
And when the plaintiffs were told to pay X amount, were they provided with proof of what taxes were paid that they then had to base it off of?
Right, so what Your Honor is referring to is the fact that we had to provide the invoices. But the provision of the invoices, the fact that whatever those might have said doesn't override the express payment obligation. Paragraph 4B.
Well, not necessarily. You see, what you're doing is you were analyzing whether the taxes were arguably reduced by a certiorari proceeding or a court order. But the bottom line here is your client participated in an industrial and commercial abatement program, and he got a 25-year abatement. We got some serious savings for making some improvements, putting in a boiler, et cetera, et cetera. And the bottom line is that you were getting tax savings, and this should have been passed along because you weren't paying the actual taxes you were charging. You were charging 52% of all the taxes that you weren't paying.
You're 52% of an amount that you weren't paying,
Weren't paying, that's what I'm saying.
all of it.
Oh, so you're sitting here saying I'm analyzing one or two words as opposed to analyzing the entire document here and getting a windfall.
Well,
That doesn't make sense to me.
Well, no, I think it actually, if you want to talk about a windfall, the windfall based on what the lower court decided would go to the tenant. So let's talk about the ICAP program. The ICAP program.
The tenant being the city of New York, meaning all of us, because we're all paying for this, council.
Well,
At the end of the day, if the city pays extra, that's coming out of my pocket, his pocket, your pocket, okay? So don't sit here saying, oh, blah, blah. Come on.
well,
The contract says that the tenant has to pay based on what you pay,
I would
period.
Okay, well, Your Honor, I would respectfully disagree with that. If you look at the Barnon case.
You say it has to be based upon a tax certiorari, right? It's your position that before there can be a credit or a deduction, it's got to be based upon a tax certiorari. Does the lease ever use the term tax certiorari?
It does, Your Honor. In paragraph 4BD, it says that you look at the full assessment. So if you look at the tax bills on page 151 of the record and the following pages, there's two parts to that. Number one is the full, complete assessment, where you take the tax rate and you multiply that by the assessed value. You get that original assessed valuation that's referred to in paragraph 4BD, okay? And if you look further in paragraph 4BD, there's one exception, okay? And that's the tax certiorari refund. Your Honor referred to the fact that the city of New York, everybody pays. The city of New York is the tenant here. The city of New York knows exactly what other abatements and programs that would reduce its taxes. It did not.
You're saying that come on. We have cases we dismiss because serving NYCHA isn't serving the city. Serving the city isn't serving NYCHA. And now the fact that the city is involved, they know everything that happens with the city. Come on.
Well, I think that
you know that that's not the way it works.
Well, I would submit, Your Honor, that the city knows it could have negotiated. It's acting as a commercial actor here, and it knew, or someone associated with the city knew or should have known about these other programs, and they could have put those into the lease as proper reductions.
The lease speaks of taxes paid.
I'm sorry?
The lease speaks of taxes paid, which you didn't pay.
But again, we did pay in the sense that we invested $400,000.
But that's not what the contract says. You'll have time on rebuttal.
Okay, thank you, Your Honor.
May it please the court, Hannah St. Marie on behalf of Respondent, City of New York. This court should affirm. When read as a whole, the lease unambiguously reflects that the additional rent is calculated based on the real estate tax payments made by appellant.
Did you waive the issue by paying for many years without a credit for the abatement?
No, Your Honor, we didn't. Certainly, the tax years 2013 and 2014, as well 2013 to 14 and 2014 to 15, the city was charged for the amount that did not account for the abatement and paid that amount. However, the subsequent years, for I believe 4 or 5 years subsequent to that, the city was charged for an amount that did include the lower amount, to make that clear.
And why didn't that wait for the city? To take counsel's argument, now I'm going to play devil's advocate, right? Because I don't have a dog in this race. He says you should have known. So if in 2 years you're paying a higher rate and then the next 4 years you're paying a much less rate, you would think somebody in the city, the light bulb would have gone off and alerted you. So again, why didn't you waive it in light of that?
Well, Your Honor, Your Honor is referring to the 2 affirmative defenses that have not been waived here, and neither of those affirmative defenses apply because the 2 years that the city overpaid are not at issue here. The city agrees that those 2 years are barred by the statute of
Because you're too late about it.
Right. They're barred by statute of limitations.
But it shows your understanding and course of conduct here. So doesn't that lend support to what your adversary wants to say.
No, Your Honor. I mean, first of all, there are two conflicting courses of conduct here, each of which is detrimental to that party. The city overpaid for 2 years. They undercharge, according to them, for several years after that. However, I'll revert back to the question here is about the interpretation of the contract. And the only thing that it matters to the interpretation of the contract is the language in there and whether it is unambiguous. And here, when you look at subsection 4B, as this court was alluding to in my adversary's argument, there is a specific provision that goes to the calculation of these payments. That is 4B1. And there is language in there that says that this obligation only occurs after the city receives a copy of the tax bill showing that the taxes have been paid. And
But then counsel also referred to paragraph D and that, you know, half a page down, which seems at first blush to be not in line with that, where they say that the original computations as well as payments of additional rent shall be based on the original assessed valuation with adjustments to be made if and when tax refund, if any, has been paid to the landlord. So it's really, it's not the clearest contract. I imagine if you were writing today, you might write it differently. But as you said, we got to interpret this contract.
absolutely, Your Honor, and we will absolutely admit that this is not the epitome of drafting.
Good.
However, I will point out that that sentence is the second sentence in that subsection D, and that subsection D is talking about a specific scenario, which is where the valuation of the property is subsequently challenged successfully, resulting in a tax refund to the landlord. And when that scenario happens, the city gets a benefit of that through credit towards future additional rent payments. And so when you look at that second sentence in that context, the original computations as well as payments of additional rent, if any, shall be based on the original assessed valuation with adjustments to be made if and when the tax refund has been paid. That means that if I may continue, that means that the city only receives the benefit of that changed valuation after the landlord receives the benefit first through the tax refund.
So in that instance, that provision is really dealing with an instance where the tax benefit is not experienced by the owner at the outset, they get it later, and then the tenant gets a benefit by way of a credit.
Yes, Your Honor.
So that provision doesn't apply to the other provisions where it's already assessed, the tax abatement has already been considered in the first instance, and so the tenant should only be charged what they actually paid.
Yes, Your Honor.
Got it.
Thank you, Your Honors.
Counsel, you got time.
All right, well, let's try this a different way then. There was a reference to the affirmative defenses, including the account stated and laches.
An account stated doesn't apply to a breach of contract here. It applies to, it's a very different kind of doctrine. It's not applicable here.
Well, I would respectfully disagree, Your Honor. The Ecleco-Nuco case from the Fourth Department, which we cite in our brief, dealt with the same, almost identical situation where you had real estate tax bills that were received, retained, and paid without objection by the
Isn't
tenants.
that more in the nature of the voluntary payment doctrine?
Well, that's part of it, Your Honor. But if you look at the account, the account stated, they meet all of the elements. And in the Ecleco-Nuco case, I would again refer Your Honors to that decision, which I think governs here. And you can't receive and retain these invoices and pay and without objection, and then almost a decade later serve us with an audit notice and say,
But
oh yeah.
Unless your invoice has a screenshot of what you paid, how do they know what you paid? Your invoice doesn't say, by the way, we paid X, does it?
Well, yes, the invoices do show what was paid, and they show that we did not deduct the ICAP abatement from those payments. And
It's itemized?
it is itemized, Your Honor.
Okay, I'll take a look at it again.
Okay.
Just to
very
go
much,
back
Your
to the
Honors.
lease, on page 97 of the record, Landlord shall give tenant landlord statement therefore, together with a copy of the taxes bill showing that the taxes have been paid. Doesn't that contemplate what's actually been paid?
Well, again, Your Honor, I think what that contemplates is that it's a condition precedent, Your Honor. That should not override the express provision of Article 4BD that actually governs how much the tenant has to pay, which is the amount based on the full assessed valuation, with one exception, if there's a reduction based on a tax certiorari refund. Otherwise, it's the
I
full.
don't see a reference, by the way, to tax certiorari per se in that section.
Well, no, well, the original computation, it talks about a tax refund, and there's the
Does it
method by
actually
which-
use the words tax certiorari?
Well, it talks about a tax refund, which
So in fact, the lease never uses the term tax certiorari, isn't that so?
well, that's the only way you can
Well,
obtain.
that's a
the
yes
tax.
or no question, is it there or not?
Well,
It doesn't have the word certiorari anywhere in there.
well, again, I don't think.
Thank you.
Okay, thank you, Your
All right.
Honors.
Lentz versus City of New York. And I gave you an extra minute, by the way, just so you know. I appreciate that. Okay. You may proceed.
May it please the court, Avram Turkel for the appellant. The appellants asked this court to reverse Supreme Court's dismissal on statute of limitations ground. The NYPD cannot use its own administrative silence to permanently strip a 24-year veteran of his retirement privileges while simultaneously denying him his day in court. The department never issued a final binding written determination, finalizing Lieutenant Lentz's duty status. That status was
It
left.
wasn't a termination, he retired.
He did retire.
And he retired while he was on a status that does not make him eligible to keep his gun.
He was never issued a final, the issue is finality. He was never issued a statement by the department that he was not entitled to the gun and badge. The city is relying, excuse me, the city is relying on the practice, on their handbook, et cetera. But as a matter of the administrative law, he is entitled to a final determination, which he did not receive. The cases that the city rely on, I'm sorry, Judge.
Mr. Takao, when on March 15, 2022, when the division denied petitioner's application because he wasn't able to supply a good guy letter, et cetera, and then it wasn't until May of 2024, when he wrote his letter to the deputy commissioner, first deputy commissioner, which is in the form of, forgive me my interpretation, reconsideration. I'd like you to take a look back and consider all that. So the question now becomes, when did the 4 months run? Because it's a 4-month Article 78 statute of limitations, correct?
Correct.
So would you not agree that filing the Article 78 after May of 2024, when he was denied his license in March of 2022, a little late?
No. City of New York, at Lieutenant Lentz's retirement, I could get to the arbitrary and capricious issue of keeping a 24-year veteran of the force on administrative duty for 39 months, even when all charges against him were dismissed, and the city decided to stop, the department decided to stop its investigation of him just before the retirement. That aside, they did not issue a no firearms statement to Lieutenant Lentz at his retirement. Those are the cases that the city relies on. Beloy, Jones, you have specific facts, right? No firearm card, et cetera. It's ambiguity. There is no finality. Lieutenant Lentz retires. He doesn't know that he
Why doesn't
wasn't.
it run from the March 15, 2022 denial of his application for a retiree handgun?
Because that denial was made on his failure to produce the good guy letter. It was not a substantive denial. It was a ministerial denial. So he goes back to
But
the
it's a
department.
denial.
That is your perception? That was his counsel's determination, and they will have to live and die with that one. You'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Bo Malin, Mayor for Respondent in the City of New York. Under this court's precedent, the determination not to issue a good guy letter and a clean retiree ID card occurs at the time of the officer's retirement. At that point, the officer is aggrieved and there's no further administrative process for him to
Can I
challenge that
assume
decision.
that this issue about if you retire and you are on any kind of restricted duty where you don't have your gun, that means that you won't be issued one when you retire? Is that clearly spelled out for officers in some police handbook or something?
So I don't have a citation to the particular provision, but it is NYPD policy that officers who retire on modified duty do not receive their gun and a clean retiree ID card. And
All right, let me ask the question another way. Did they assert that they didn't know this policy existed?
So he now asserts that. However, at the time, he did file a timely Article 78 petition challenging the refusal to return his gun and badge, in which he stated that he, should have been taken off modified duty at the time and been given.
But that was dismissed, right? For failure to serve somebody.
Yeah, and so that was the time for him to challenge it. He knew it was a final decision at that time.
That was in 2021.
I'm sorry?
That was in 2021 that he did that, by
Correct,
the
Your
Article
Honor.
7.
And then the 2022 license denial is only further confirmation that should have made clear to him that it was final. But in any case, even at the time that he retired, he knew that this was final, and there's no further process. When an officer
When they said that it was the March 2022 letter, when your response to him was, we can't give you a gun because you failed to produce a good guy letter, but they failed to produce the letter because he was on modified duty because he wasn't entitled to it. So that's more than just a procedural denial, isn't it?
Correct, Your Honor. It's a denial in the substance that he didn't have the good guy letter, and that, again, as you're saying, it's all traceable back to the fact that he's on modified duty when he retires. So at that point, there's no special administrative process or further procedure to go through to determine whether you should receive your gun and badge back. You didn't have them when you were in the service. You're not going to be given them on retirement.
Did the March 15th, 2022 denial, was it a provisional denial? Did it indicate that the petitioner had some sort of leave to submit additional documentation or to take further steps?
No, and that wouldn't make sense because at the time of retirement and you don't receive the good guy letter, that's it. There's no further process. And then the denial of the license is just based on not having that good guy letter, which again is just based on being on modified duty at the time of retirement. So the idea that this is still something that he thinks is sort of pending somewhere because no one stamped his ID card, no firearms, there are different, you can be denied an ID, you can have a no firearms ID, or you can be granted an ID. Those are just different final determinations. There's no further process, but we're waiting for a written determination, which is not required by the CPLR, to say you need a no firearms stamp before this is final.
Thank you.
Thank you, Your Honors. You may,
You know that the statute of limitations are a difficult hurdle in cases such as these. I mean, you've got the further complication that after all, you bring an Article 78 proceeding in April of 2021, and it's not served. For whatever reason, that ends up getting dismissed. So back then, the petitioner already understood that he needed to be doing something about this good guy letter.
that finding was made in 2021, right? And it did not and could not evaluate NYPD's subsequent decision to withdraw the disciplinary charges in late April 2021. This is the facts of this case are interesting in that regard because you have this 24-year veteran of the force. He has COVID-19. He's got World Trade Center related health issues. He plans a retirement, but he's been on this modified duty for 39 months for really no reason, an arbitrary.
So stop. No reason?
No reason.
That ultimately they decide we're not moving forward, it's whatever the term is. His wife accused him of domestic violence.
A court dismissed those charges in 10 days.
2 years to get there, right?
2 years.
You said 39 months.
Not 2 years to get to the dismissal. A New Jersey court dismissed his ex-wife's domestic violence complaint within about 2 weeks. Then the city of New York, the police department, decided to extend this modified duty for another almost 3 years. It was not, the modified duty appeared to be extended based on a parking ticket in 2018. It is directly arbitrary and capricious that they kept him on this modified duty. It has nothing to do.
Mr.
My colleague
Tricala,
has a
I'm a little confused. Your client sued the police department for discrimination based on what you've just described. Just bear with me for a second. Based on what you've just described, that he was wrongfully put on modified duty all the way up to the time of his retirement. And he claimed violation of his rights, singled out for adverse employment conduct. And yet, this court in 2022 affirmed the dismissal of his discrimination claims, and this is what the court said. Nothing in the complaint indicated that his suspension and placement on modified duty were for any reason other than disciplinary action taken after his arrest for domestic violence, et cetera. I mean,
Court's finding was based on discriminatory animus. This case is about arbitrary and capricious for the administrative determination. That's the difference. Thank you, Your Honors.
Vermio versus Master Plumbing. May proceed.
Good afternoon, Lisa Gokulsing for 3GR427 and Bettina Equities. The Court of Appeals has decided that same-level accidents are recoverable under 240, where the item is capable of generating a significant force. And this court has, on a number of occasions, affirmed summary judgment for the plaintiff where the item is definite, where we know the weight, where we know the height, where we know how the accident occurred. In this case, however, the plaintiff did not know the weight, he did not know the height.
We have good approximations from him and his coworkers. All of his coworkers say that the piece that hit him was between 7 and 9 feet tall, and that this pipe, which weighed at least 20 to 25 pounds, was just left leaning up against the wall instead of laying on the floor where it would not fall over and hit him on the head.
That's accurate.
Right.
The plaintiff himself says that he was by himself at the time that the accident occurred. His coworker, Humberto Rodriguez, he said that the accident occurred outside of the room where the plaintiff says that the accident occurred, and that actually the plaintiff was walking.
I thought you said he was alone.
That's what I'm saying, that there's no consensus.
So either he's alone or his coworker was there. It's got to be one or the other, right? So his
Agreed.
coworker can't say he was alone and then say, I saw him get hit by something outside of the room.
Right, but that's what I'm saying, is that in moving for summary judgment, the burden is on the plaintiff to demonstrate that there are no triable issues of fact, and that did not happen here.
This man's face got cut open by this pipe, right?
It did, and he recovered.
And he ended
under
up at
workers'
the
comp.
hospital having
Absolutely.
his face sewn up, correct? So we know something hit him.
We know that for sure.
All right, so then the issue is whether that something was properly secured or not. And what evidence do you have that it was properly secured?
Well, the question is whether the...
No, that's the question. I ask the
Yes.
questions. You answer them.
Under
so
the law.
tell me, what evidence is there that this pipe was properly secured?
So,
Because obviously, it fell from somewhere, hit him in the face and the head, and cut his face open.
yes. There is no evidence that it was properly secured. It was leaning against a wall, and according to his own testimony, it should have been laid on the ground. The question that the law asks, though, is whether it was an item that should have been secured. And in the numerous cases that the plaintiff cited, these are items involving supply areas where things are stacked and required securing. In this situation, this is not a situation where this was an item that was in a supply area for the particular purpose.
This was a makeshift storage room based on the testimony of every single worker who testified.
Depending on where the accident occurred, because again, the
Well,
plaintiff.
wait, so I'm confused. So why do you keep saying about depending on where the accident occurred? He testified where it happened, nobody else was there. So how did somebody else testify that it happened somewhere else if nobody saw it?
That's what the coworker testified to. And the plaintiff, in moving for summary judgment, put in the testimony of himself, along with Humberto Rodriguez, and his other coworker, who says, I was not there and I didn't see anything.
So if he wasn't there and he didn't see anything, so how is his testimony relevant to where the accident happened?
Well, the issue is that we don't know anything about the accident because there can't be an established set of facts if we have people who testified on this record that they were there, they witnessed the accident, and it happened in a totally different way.
I don't remember reading anybody else saying they were there and witnessed the accident, but you'll have time on rebuttal.
Okay.
Next.
Good afternoon, Your Honors, and may it please the court, Elliot Hamilton from Master Plumbing. As a preliminary matter, my friend here abandoned any argument regarding our claim that the contribution and common law indemnification cross claims should be dismissed. So we ask that the honors reverse the order at minimum as to dismissing those claims. And with respect to the common law negligence claims and the contractual indemnification claim, we established our prima facie burden that the pipe that allegedly fell on the plaintiff was neither placed by us or that we were responsible.
You were the only, I'm sorry, you were the only contractor on site who was dealing with pipes. Your men were cutting pipes that morning.
That's
and
correct.
Although there's evidence in the record that says, oh no, the only pipe I cut was 3 feet long, others talk about 7 and 9 feet.
Yes, but they were. Yes, but the testimony that we proffered in our motion for summary judgment was that the only pipe that we handled that day was the 3-foot pipe, and
that is impossible based on the record here. Okay, that's impossible. It took your men all morning to cut 1 3-foot pipe. The record says that Master Plumbing was cutting pipes on that floor all morning. And that in the afternoon, when this gentleman went in there to retrieve something else, is when he has the accident. So that just belies the record that your men who are working on restoring and removing pipes for this renovation only cut 1 pipe, and that 1 pipe was only 3 feet long.
But we had additional testimony that even with the 1 pipe that we had, we placed it on the ground. There was none of our employees observed any pipe being laid out on the wall as well. So our position is that the evidence that we presented from the testimony that we dealt with that 3-foot pipe, like even to assume that we were responsible for this other pipe, that room was
Is there
designated.
any evidence that anybody else had pipes, working with pipes other than your company? Is there any evidence, even an iota of evidence, that any other contractor was dealing with pipes? The answer to that is no, right?
That is true, Your Honor,
Okay.
but we submit that there's far more testimony with respect to Pelham workers going in and out.
So what you
they were responsible.
What you want us to believe is that you guys cut pipes during the morning, but somebody else came in, saw pipes laying on the floor and stood them up. That's what happened here?
Well, we said that the entire thing is speculative. Well, to our point, the only evidence that the plaintiff argued against the testimony we proffered is indeed this point that just because we're a piping company does not necessarily means that we were responsible for it.
You're the only piping company on the site.
But we also
the only one.
That may be, Your Honor, but at the same time, that like Pelham, if Pelham was responsible for taking out the garbage and it also took out our garbage as well, we submit that, and there was more testimony as proffered by the evidence that there were workers from Pelham that were going in and out of that apartment, which they designated for trash for them to dispose, then we submit that that with the evidence that we presented, that we only worked with one pipe, that none of our people observed, placed a pipe on the wall or anything along those lines, that was sufficient for us to meet prima facie. Where
It was prima facie, but there was other, you may win down the line, but there was other evidence in this record that did not agree with your witness's testimony, and that's why where we are where we are today.
You'll have time on rebuttal.
Thank you, Your Honor.
Who's next? You have 3, right? 3 minutes.
Okay, great. Colby Forrest for the plaintiff respondent. So it is our position that the lower court properly granted plaintiff partial summary judgment on his Labor Law 240 subsection 1 cause of action. Just briefly, I want to touch on the 3-foot pipe that counsel just mentioned. So that specific pipe was never identified as the one that struck plaintiff. And no one knew exactly where that pipe was placed, whether it was against the wall or on the ground. And then also briefly touching on the trash materials that Pelham was throwing out. I would contend that you are still responsible for your own materials, even though it was potentially Pelham's responsibility to dispose of
That
these.
is not the strongest argument, counsel.
Okay. I was just.
That is not
Okay,
the strongest
that's fine.
argument.
Okay. Okay, well, then I would contend that plaintiff being struck by an unsecured ground-based load is the type of occurrence that labor law was enacted to prevent.
Wasn't there, contrary to what your friend said earlier, the accident was witnessed by Rodriguez, another Pelham coworker, who said he saw a black pipe roll and hit the plaintiff. So I'm not sure where your friend got the position they got, because there is testimony to that effect. Plus, as my colleague pointed out, your client described the dimensions and the estimated weight of the pipe that hit him. Am I correct?
Yes.
And we recently issued a decision about in Aguido, which is somewhat comparable here, where with a similar weight scenario. Am I correct?
Yes.
So there's no real concern with the 240 ruling.
Correct. Yeah. Yeah. So if you have no further questions.
Thank you.
Okay.
Good afternoon, Your Honors. Louise Cherkis for
Please bring the
Pelham.
mic up, you're a little taller.
Okay, I'm here for Pelham Construction, and I'm here on the claim for indemnity by us. And it's, I would rest on my papers, but since Pelham is being mentioned here as it is, I would like to point out that plaintiff was our employee, and he had left the area that he was working on. He wasn't working with debris. He wasn't involved with debris at the time.
He was sheetrock. He was getting
doing
sheetrock.
sheetrock. He was looking for another little piece to use. He goes in that room, and so him walking in that room, there's nothing wrong about that. That's nothing that would create something in the indemnification aspect that they're claiming. Also, Master Plumbing and us have that same indemnification agreement, and parties are responsible for their own debris. So if we are now, that unless the court is in agreement with Master Plumbing that they could not possibly have put any pipe in that room, there is, what could be in that room could have been pipe from Master Plumbing. It certainly wasn't us. We had not put it in. And in fact, in this case, we do have a almost 40-page transcript of what we argued in front of the judge, and that whole area was discussed. So the fact that it's a short opinion, it isn't a short opinion because he was right in front of us, and we had this full argument. So if there aren't any other questions for me, I'll rest on my papers.
Thank you so much. Counsel, you have rebuttal time. You have a minute.
I just wanted to point out, Judges Friedman and Schulman were on the Argueta case. That involved a 9 to 11-foot post that was 150 pounds in weight.
Yeah,
when-
but we also said regardless of whether their post weighs 30, 50, or 150 pounds, the fact remains that the pole fell on the plaintiff and the elevation differential involved cannot be described as de minimis.
Well,
So whether it's 150 or here 30, 35, this was a pole leaning against behind the door that fell on the plaintiff, as my colleague pointed in, hit him on the head, cut him, et cetera. So I think that case works.
I think the problem with that case is that then you have to look at the Cullion case and the Melendez case. Both cases, this court denied summary judgment to the defendant, but the court denied summary judgment finding that there were issues of fact as to whether the object could generate the significant force required under Labor Law 240. That's not to say that this is not an ordinary construction accident. It is an ordinary construction accident. 240 was not appropriate. And based on the arguments today, I would ask that the court also grant summary judgment on my contractual indemnification claim. Thank you.
Thank you. You reserve 2 minutes for your rebuttal.
Thank you, Your Honor. So even assuming for the sake of argument that it would be our pipe, there is testimony from the plaintiff that stated that our employees were not responsible for placing the pipe against the sheetrock. That's in pages 375 and 376 on the record. So at best, we did not place the pipe in its position, and at worst, we still maintain that
But I thought that there was testimony from plaintiff's coworker that he observed the plumbers, that's your guys, cutting pipes earlier in the day and standing them up against the wall. So there is testimony from people different than your testimony. Again, doesn't mean who's winning, it just means there's issues of fact at this stage.
Understood, Your Honor. And I would also just state with respect to the contractual indemnification claim. Again, I believe that the record right now does not establish any negligence or at least no issues at this juncture with respect to Master Plumbing that.
But it arises out of the work.
Right.
There's language in the indemnity provision that arises out of the work that would arguably give them contractual indemnification.
But we would submit
It's a much lesser burden than showing negligence, et cetera, right?
But we would submit that based on the record here that we have not based on the record here that we were not responsible for creating the dangerous condition here. So the indemnity provision should not be triggered here, and it should warrant dismissal of the contractual indemnification claim, especially if Your Honors were to agree with us that the Labor Law 200 claim should be dismissed because the evidence provided by plaintiff against our motion for summary judgment was based on mere speculation. We ask that you reverse and dismiss the complaint and the cross claims against us.
Thank you so much. Matter of estate of Robert J. Giordanella.
Thank you, Your Honor. Brian De Laurentiis for Appellant and Giordanella, who is seated over there.
So
we're here to...
your application is pursuant to EPTL 5-1.1-A and the subdivision D, and the statute goes through that you can get an extension of time to file right of election. You've got to do it within 6 months and then no event more than 2 years after the date of death. But that can be extended. But at the end, you can't come in more than 1 year after letters testamentary are provided, right? That's what's provided between D1 and D2.
Yes, that's true, Your Honor.
I haven't gotten to my question yet. So my question relates to D3, which there's been no focus on that here. I recognize that. But what D3 says, the time limited in this paragraph for making an election is exclusive and shall not be suspended or otherwise affected by any provision of law, except that the surrogate may, in his or her discretion, permit an election to be made on behalf of an infant or incompetent, and we're not dealing with that here. So what does it mean when the subdivision 3 says that an election is exclusive and shall not be suspended or otherwise affected?
I would submit that perhaps that D3 would be interpreted in a way that extensions of the statute of limitations for the appointment of an executor that you would find in CPLR Article 2.
Well, this is not talking about appointing an executor. This is specifically focused on asserting the elective share.
But it does, because the timing runs off of the appointment date of the fiduciary. And I would add to that, Your Honor.
No, but it says the time limited in this paragraph, which is subdivision D.
Yes.
Dealing with the asserting the elective share.
Yes. Well, the 2010 amendment.
How does that provision in the statute allow you to seek to extend the time beyond the 1 year otherwise set forward in subdivision D?
Let me explain it.
1 year after the appointment of the issuance of letters testamentary.
Let me explain it this way, as I read the statute. The statute is a temporal construct over decades of exception upon exception. So we have D1, and D1 says you must make your election within 6 months and not later than 2 years, except if D2 applies. Then you go to D2, and D2 says you can go to the surrogate for reasonable cause.
And get another 6 months.
And you can get another 6 months.
Or get past the 2 years.
As long as, another 6 months, as long as these conditions occur. And then we have the 2010
But D2 doesn't say anything about getting past the additional 6 months after the issuance of letters testamentary.
I believe D2 does say you were able to get past it.
It allows you to get past it on the 2 years. Good cause gets you past the 2 years after the date of death. It's very specific in the way it's worded. That does not relate to the 6 months after the issuance of letters testamentary.
Exactly that. Does the good cause apply to the letters testamentary? Or is it just to the 2-year time period from time of death?
There are numerous reasons why it applies to the entirety, to the totality of the circumstances.
And so I don't know how you say that, because except that the court may, in its discretion, for good cause shown, extend the time to make such election beyond such period of 2 years.
And now I'm going to give you the time to actually answer.
Go ahead. So from my perspective, the legislature's 2010 amendment is an exception upon an exception upon an exception. The use of, as I note in my brief, the semicolon and the use of the word except rather than the use of the word earlier in the statute provided makes a grammatical construction possible. In addition, when you look at the legislative history, because
well, you noted that in your reply brief. I don't mean to cut you off.
And I don't need to repeat that, but
I understand, but I'm not saying that to cut you off. What I'm trying to say is that the focus was just the 2 years and not the 1 year period that my colleague keeps harping on. In other words, the focus of the 2010 amendment was for good cause shown to allow the court in its discretion to extend the time beyond the 2 year period from the date of death.
The focus of the statutory amendment is to allow any spouse for a good cause at any time to come forward. And this inside baseball statute of limitations as to the appointment of the date of letters, that's not in the legislation.
I mean, that just whites out totally, according to you, that 3 could just be, is just wiped out completely. If you've got good cause, you just dispense with subdivision 3.
No. What I'm saying is that it is, what the amendment affects is essentially a burden of persuasion depending on the timing when it is filed. And the removal of a flat date for it to end is a conveyance to the surrogate to use good cause as a standard for any situation in which a spousal election seeks to be utilized, because this is about the dissolution of the marital economic partnership and to make sure that the surviving spouse retains and does not have a forfeiture of, in this case, her interest that she spent 64 years building.
My colleague has a question.
We've been talking primarily about the statutory interpretation issue.
Yes.
So I'd like you to, if we assume that equitable estoppel may apply to the time periods relating to spousal election, could you just marshal for me your the evidence that you have that supports the elements of your equitable estoppel argument?
Sure. So the equitable estoppel is established because Anne relied upon two people she properly vested her trust in. One, her daughter through her power of attorney, and two, her lawyer who had accepted the dual representation. They both stayed willfully silent with actual knowledge of what she could do. And they did that to keep her
Any evidence in this record?
from doing.
Is
What?
there any evidence in this record at all that anyone told this 85-plus-year-old woman what her estate was worth? The real number.
No.
Did
Not-
anyone tell her that as a wife, as a widow, she had a right of election on the estate? Did anyone tell her that?
None until she retained me, Your Honor.
And when her daughter put these pieces of paper under her hand 2 months after her husband died and 3 days after getting out of a rehabilitation hospital and said, "Mom, here, this is so that the will doesn't have to be probated." I watched the video. Did she say anything else about what it meant?
Not one word, Your Honor.
I heard the son say, "Mom, do you know what probate means?" And that poor woman sat there silent. She didn't say a word throughout the entire video. Not a word. All she did was sign.
That's correct, Your Honor.
Okay? She gets placed another piece of paper. "Mom, this is your will. And under this, you're going to give your New York house to Carlo and your Florida house to me." And I hear the son say, "Mom, is that what you want to do?" Mom says nothing. Daughter sticks the piece of paper under her mother's hand for her to sign. What was not present in the video was her lawyer. Was he there?
No, Your Honor. And I just wanted to point out very.
Who prepared those papers that were put in front of her to sign?
That lawyer, Your Honor, and I want to add one important fact to that. If you take a look at the self-proving affidavit at the end of the will that she signed that day, missing is the customary paragraph saying that this lawyer, Greg Weiss, supervised the execution of this will. It was planned.
May I?
Yes, please.
Mr. De Laurentiis, a couple of points, if you can clear up for me. My learned colleague here raises the issue of D3. Maybe I'm missing something, but I don't recall any argument or any argument of this section somehow limiting your ability to challenge the statute of limitations or to defeat it before the surrogate. Bear with me. I don't recall a single word, nor do I recall any argument in any of the briefs that somehow this subdivision 3 somehow should defeat a good cause shown challenge, which you've made here, as well as the application of equitable estoppel. Am I correct?
That's correct, Your Honor. I would point to D1. The D1 says you have these timing deadlines unless D2 applies. It makes no reference to D3.
No reference to it. Finally, the other point is, and I think you raised so that I'm clear, she had a POA as an attorney in fact. which meant that she really should be her mother in terms of functioning. That's the whole point of an attorney in fact, which means that while built into it is sort of a built-in fiduciary responsibility, she should have exercised the right of election on behalf of her mother.
She certainly had the capacity to do so, and yes, she should have done so. And I would add one other point to that, Your Honor. If you look in the record at the power of attorney, it is not the Blumberg form. It does not contain.
Oh, no, it was a lot broader than that. You
Absolutely.
Could give gifts. I mean, she just gave away the farm.
Well, 14 buildings in the East Village, yes, Your Honor, yes.
Yeah, and am I correct that there was a lot of argument in the papers about the lack of due diligence of your client?
Yes.
So let's talk about the due diligence, because due diligence would have required her to know things in order to act on them, right?
Yes, that's correct.
And am I correct that by the time she learned all of the things she needed to know in order to exercise her right, her statute of limitations, according to them, had already run, right?
Right.
Okay, and she doesn't, the taxes which revealed the true value, because she was told by her lawyer that it's worth $2 million, right?
That's
when
what
it's actually worth $45 million.
Right.
Right? But she doesn't find this out. She doesn't actually get a copy of the tax returns, God bless you, until after
December of
the time
2024.
has run.
It was first requested in May of, I forget whether it's May of 23 or 24, but it was first requested in May, but it was when, not to go beyond the record, but I spoke to Mr. Weiss, and Mr. Weiss provided me with a copy of the tax return in December of 2024.
Okay, and there was another thing. Any other questions
Mr.
while I
Weiss
think of mine?
ends his relationship with the petitioner in April of 2023, right?
He terminates the relationship.
Right.
1 month after the
and
statute of
thereafter,
limitations
she consults 3 different attorneys, right?
Yes, you could
She brings
count
a
it that way.
proceeding against her daughter in family court during that period of time, and it's not until November of 2024 that she puts in the petition for filing the right of election.
That's right, Your Honor. If I could just make one point about diligence. First off, these cases that we're relying on below about diligence, they have a trigger, right? There was sexual abuse, or there was the failure to pay a promissory note. There's no trigger here. There's no trigger here. And what is reasonable of an 89-year-old woman with an 8th grade education? It's not that she did nothing. Okay.
When did she bring the family court proceeding?
What?
When did she bring the family court proceeding?
March of 23, I want to say, Your Honor. Hang on one second.
November 23. November 23. I have a chart.
Yeah, November of 23. My point being, with regard to due diligence, is that every few months, she took some step to try and vindicate her interests. She went to the disciplinary committee. She went to family court. She retained this lawyer who did demand the tax return.
When
to
did
see
she
what
go
the
to the
true value was, and then
disciplinary? When did she go to the disciplinary committee?
I'm sorry?
When did she go to the disciplinary?
That was first in 2023. That was, I believe, in April of 2023.
Am I clear that it was Mr. Weiss who terminated the relationship when she sought to revoke the trust?
Yeah, not only did Mr. Weiss terminate...
Because the letter in the file says, I am no longer your lawyer, so he cut her off.
Not
like she fired him.
No, he cut her off, and then he had the audacity to send me a letter rejecting the notice of spousal election as untimely. That was chutzpah.
Thank you.
Good afternoon. May it please the court. Frank T. Santoro for the respondent, the executor, Christine Renzi. The statute here, EPTL 5-1.1A D2, appellate authority, surrogates court authority, prominent commentators and treaties all make it very clear that the appellant's right to make a spousal election was extinguished 12 months after the issuance of letters testamentary.
So when a person who is supposed to act on behalf of you and violates everything that that means, that person has no recourse, is what you're saying?
If you're referring to the power of attorney, Your Honor?
Yes.
That was revoked in June of 2000.
After her statute of limitations had run. So let's not play that game, okay? Because by the time she knew what was going on, time had already run out. So you would have been able to make this argument even if she had done it a month after Mr. Weiss terminated her, okay? So please.
So she had then from June of 2023 until November of 2024, which again is more than a year. If you were
Is she not entitled? She had nothing. She didn't have a copy of the will that her daughter had her sign. All of this stuff she doesn't get until later. No, that's exactly what happened.
Does a copy of the will that she signed for herself have anything to do with her right of election against her spouse's estate?
There is absolutely no nexus between her will and revocable lifetime.
You're telling me she was counseled on what she was giving up? Is that what you're saying?
I'm not saying
That
that.
your client properly counseled her on what she was signing and what she was giving up?
I'm not saying that at all.
You can't, because she wasn't.
The power of attorney doesn't have a duty to counsel.
How about her lawyer?
Well, her
The lawyer didn't have an obligation to tell this woman what her rights were?
The relationship with the lawyer ended in March of 2023.
1 month before the statute of limitations ended and before she got any paperwork. Once again, it is nothing. They gave her nothing that she could pursue her rights with in a timely fashion. Nothing.
Assuming that the lawyer had a duty to inform her of this right of election, right?
Really? That's a question?
She still had...
Counsel, wait. That's a question? You are an attorney for a client. Her estate is worth $45 million. She has a daughter who is quick to tell you, give me papers so that I have control of everything. And she is not entitled to counsel? That's a question here? Really?
Two things, Judge. The reason why I brought that up
Who
was...
put your daughter in charge of this?
I'd like an answer I want an answer to this question. Is that lawyer not duty-bound as a lawyer, the canon of ethics, the disciplinary rules that we all follow to guide her and at least inform her? Look, I get it. $45 million estate, the tax consequences were going to be devastating to the family. She had the right to be told that and to say, look, you can do this is what it's gonna cost in taxes, or we can find another way to make sure that you're comfortable and that your children and grandchildren are comfortable. That's how she was supposed to be counseled. No?
It depends on what the scope of her engagement with the lawyer was. If he was just engaged to prepare her estate planning documents, it's not her estate, it's her husband's estate. It's two different things.
Really?
Yes.
Really? It's not her estate?
That's correct.
She's married to this man for 64 years. They build that together. And I recognize how for some people they may say, oh, she had an 8th grade education. What did she really contribute? Under the law, she's entitled to half. Right? And she has a lawyer who doesn't tell her that?
I don't agree with that, Your Honor. She's not entitled to half. He's not
It's a
allowed.
third, isn't it? The right of election? The right of election is a third.
Okay, so a third. Did she get a third? She got $2 million. And she's getting that piecemeal through a daughter who hasn't even given her $200,000 in 3 years.
So from March of 2023, when the attorney-client relationship ended, even if you were to toll that 1-year period following the issuance of letters testamentary, 18 months passed. In that 18-month period, she had 3 other lawyers. She had the diligence to go bring a grievance against the attorney. She had the diligence to bring a family
And
court
what
proceeding.
happened to that grievance?
It was dismissed.
And the statute speaks, you speak of the 18 months to the 19 months, the statute provides a 1-year period to assert this right of election. And she had more than that after the relationship with the power of attorney ends, the attorney client relationship with Mr. Weiss ends, more than a year went by.
That's correct, Your Honor.
Sir, in your view, are the time periods associated with the spousal right of election, are those statutes of limitations? The provision that provides the underlying time within which a spouse may as of right make the election, on the one hand, and then the other provision that allows the surrogate, provided certain conditions are met, to extend the time. Are those essentially statute of limitations, or they are statute of limitations?
The courts have referred to them as statute of limitations, or on the other hand, a condition to a substantive right.
And yet it's not like a statute of limitations in that subdivision D3 and a provision which you see at no other statute of limitation provision in our law speaks of it being exclusive and shall not be suspended or otherwise affected. Is there any statute of limitations in our law that has such a provision about it?
And that's what that statute, Your Honor, takes it out of the world of equitable estoppel.
The other question is, who put the daughter in charge of the estate?
The decedent. And of course, in our system, the decedent's intent is of paramount concern in terms of who is administering the estate,
Even
who is
though the
making the election.
decedent's intent illegally stripped his wife of what she was entitled to, okay? And I believe my colleague has a question about your declaration about equitable estoppel, and I can't wait to hear the answer.
Sub 3 seems like a very, potentially very powerful statement. Was that raised before the surrogate?
It certainly was. It was in our brief. We referred to D3, and we essentially said, all you do is look at the statute and the case law promulgated under the statute. You can't bring in anything else.
There's really only one case, and that's Hornby from the 4th Department, right? And in that case, there, the election was done 9 years after the fact with a spouse who had a competent lawyer who was actually working for her. Completely different case.
The 1 year is what matters, Your Honor, and it's Hornby's a sister.
I understand, but we're not bound by it.
And the surrogates courts who deal with this every day have followed Hornby, and everyone who comments.
Because they have nothing else to go on. That's the only case.
But sir, did Hornby talk about equitable estoppel, or was Hornby engaged in that statutory interpretation question that we talked about earlier?
It was certainly the statutory interpretation.
There's no equitable estoppel analysis on an appellate level at this time.
No, there isn't, because I think because of two reasons. D3, right, which says don't do it. And then when well, I could apply equitable estoppel in this case, but I will if I guess I'm asked.
Marty, sorry, Judge Schulman, if you have additional questions, please.
I want to understand something.
Sure.
If the 1 year is so rigid, then the second part of the phrase of the statute, which allows up to 2 years from the date of death, correct? So we already have built in an extra year. And not only do we have built in an extra year, despite the rigidity of the 1 year period from the date of letters testamentary, but we have the ability, or the statutory ability for a court in its discretion for good cause shown to go beyond the 2 year period, despite the rigidity of the 1 year and despite the 2 year period. Am I correct? Based on the plain language of the statute. Yes or no?
I'm not sure.
Okay. My colleague keeps raising the point about this is exclusive, no wiggle room. So as you raised, you have 1 year from letters testamentary to exercise your right of election, correct?
Correct.
Very clear in the statute. Then we said, you could also have up to 2 years from the date of death, correct?
Not if 1 year has passed since the letter is issued or there's an accounting decree.
Okay, but then for good cause shown, you can go beyond the 2 year period.
Not if more than 1 year has passed since the date of the issuance of letters or there's an accounting decree. The 2 year period is not available if 1 year has passed since the issuance of letters or there's an accounting decree on the fiduciaries.
Oh, but there's no accounting degree here. We know that
That's
that
right.
hasn't happened.
So the
we're
the
good.
prescription is the 1-year period has passed. And there's a reason for that, right? When a fiduciary gets letters testamentary, they're administering the estate. They're making tax elections. They're making distributions. They're doing all sorts of things that.
If what the petitioner is advocating for today was to be upheld, that means at any time, any estate which has been distributed, which the parties have their funds and the estate has been dissipated, you could undo it.
It would create absolute chaos.
Where there has been a showing of good cause, like here, where the widow is not advised of any of her legal rights by not her lawyer, by not her daughter, power of attorney holder. No one tells her what her rights are. If that's what the legislature intended, I don't know. What I read in those legislative comments don't seem to support that, but we shall see. You have time on rebuttal.
Thank you, Your Honor.
Thank you.
I think the only point I want to make on rebuttal is that this interpretation reads the 2010 amendment as a nullity. It says, oh, never mind, you forgot this point, legislature, so we're going to stick to this one. And the other thing I want to say is this. The legislature is here for the surviving spouse. They're not here for the remainder beneficiaries. They're not here to make sure there's no interest and penalties on taxes. They're here for the surviving spouse because the surviving spouse has an inchoate property interest in the decedent's property.
Counsel, my understanding of the legislative history that you sort of hit home again in your reply brief was that except for a letter from the Surrogates Association that came in after this law was passed, or the amendment was passed, the 1-year period that my colleague keep going over and over again about, and your friend did, really was not relevant now. What became relevant with this amendment is the ability that if someone had a basis to go beyond the 2 years, they could. It was the 2-year period, not the 1-year period.
That's correct, Your Honor, and I want to add one other thing to that, which is that this letter appears 6 weeks after the legislature unanimously amends the statute, sends it to the governor. Then this letter comes in, but you know, there are 6 letters. 3 other letters totally contradict what Surrogate Holtzman had to say in his Surrogates Court Association letter. So it's just literally pulling a letter out and inserting it into the statute as some sort of inside.
So tell me what you think the 2010 amendment does for your client here.
The 2010 amendment allows my client to assert that she has good cause, even though it is more than 2 years from the date of death of her spouse, and that the other provisions, well, there's no accounting degree, so that's not relevant. And as to the letters testamentary, you know, okay, maybe it's a little bit higher standard because the statute says you have to have reasonable cause. And as I say in my brief, it's like saying, well, I want to come in and amend my pleading. And so how could I contrast it? It's like seeking to amend a pleading versus seeking to vacate a default.
Is it
different
possible
standard,
that the reason...
But something must be tendered.
Is it possible that the reason you can, for good cause, seek this extension more than 2 years after the date of death, because it's quite possible that you may have an estate proceeding that's not started for more than 2 years after a decedent passes away?
I just don't think the legislature is playing in the margins, Your Honor. They're not playing in the margins for those kinds of cases. And to your point, I mean, seeing the video where Anne signs the waiver without execution, that accelerated the entire process here, so that there was no contest before the fiduciary was appointed. The will could have been challenged.
Sir, if we were to disagree with you on your reading of the 2010 amendment, but we were inclined to agree with you vis-a-vis equitable estoppel, what would happen? And we said, okay, we are now remanding. You fill in the blank after when we said this is remanded to surrogates court for blank. What would have to happen next?
Well, I mean, I would say that it would require under some QC at least a factual hearing if you're going to remand without further instruction. But of course, I would hope that you would find that there are sufficient facts pleaded here to invoke equitable estoppel as an appellate remedy.
And then what would the effect of that be
And
going
so
back?
what would the order read? The order would read that the motion to dismiss is
No,
denied.
but what would the impact of that be practically?
That her spousal right of election, the petition to file her spousal right of election is allowed and shall be given legal effect, because that's the way SCPA 1412 is written. But that even though late and delayed, it shall be given legal effect, and that she is entitled to withdraw 1/3 of the state's assets.
I mean,
pursuant to the statute.
basically what you're asking for is summary judgment. That's what you're asking for today.
Your Honor, these are petitions, and petitions are supposed to be rapidly decided. So there's petition, there's
No,
objection.
I just asked, what it sounds to me like what you've just asked for is summary judgment from us.
I do my best for my client, Your Honor. Yes, I would like.
But it isn't. This is a pleading scenario here. They're dismissing the pleading based on, as a matter of law, because of the statute of limitation. That's what's going on here. Wouldn't, at the very least, it require potential discovery if we believe that there's a pleaded basis for equitable estoppel, and then we need to really explore whether there was reasonable reliance or detrimental reliance or by omission as opposed to commission, by refusing to tell information as to the value of the estate, by refusing to tell your client that she had a right of election, both on the part of two fiduciaries, the daughter as a trustee, and before that as the POA, and of course Mr. Weiss as a conflicted lawyer for both the daughter and the estate and your client. Wouldn't that require discovery and further exploration, certainly beyond the pleading stage?
In the alternative, on my cross motion, I had asked for discovery. And
so then it's not summary judgment.
No, that is not summary judgment. However, I would say that.
Counselor, I was just saying what you just asked us for. It sounded to me, speaking for myself, like you're asking for summary judgment from us.
If I could further to that point, Your Honor. Further to that point, I would say that the facts tendered here show, and the lack of objection by a respondent on any kind of factual basis, show that summary judgment can now be awarded, which is, I believe, CPLR 409.
So that's an interesting point. I don't want to. There was no objection to any of the allegations you raised as to, with the exception of lawyer argument, as to any of her factual claims here.
Where was Mr. Weiss's?
In other words, where is, in terms of the manner in which she signed the papers, the withholding of information, et cetera, et cetera? Am I correct?
That's correct. There's no factual contest by the other side.
And the grievance committee didn't dismiss, they didn't even investigate.
Why? There was no investigation.
There was no investigation.
No, that's true.
Thank you.
Thank you, Your Honor.
Lilly versus State of New York. You may proceed.
Good afternoon. May it please the court, Craig Buckeye from the law firm of Phillips Lytle LLP. On behalf of the appellant, Edward Gibbs, a member of the New York State Assembly. I would divide our arguments on appeal into what I would call immunity-based arguments and the non-immunity-based arguments. So first of all, with respect to the immunity-based arguments, the immunity-based arguments are dual in nature. First of all, the fact that the assemblyman is not an employer for the purposes of this lawsuit, whether under the New York State Human Rights Law, the New York City Human Rights Law, or the FMLA.
He supervises him?
Excuse me, Your Honor?
He supervises, his office supervises him, correct?
The assemblyman
His office hired him, correct?
Yes.
And his office tried firing him.
The assemblyman terminated his
Okay.
staffer, yes.
There are many people who work in state government who hire people. They are their employers, although they don't pay their salaries out of their pocket.
Yes.
Okay.
And I
That
would,
same rule applies to your client.
well, I would say one needs,
I'm an employer. I don't pay my court attorney. The state does, but I am still her employer.
I would disagree because one needs to look at the definition
If
of
I
an employer.
violate her rights and say some discriminatory things to her that are inappropriate, I would be in violation.
Well, that would be with respect to a case where, let's say, discriminatory things were said to someone
Or
in the course of
discriminatory
employment.
action like is being alleged here.
Well, what's being alleged here is termination of the staffer.
Right.
And under the executive law, New York State Human Rights Law, Section 290.
This happened after a visit of this employee at the hospital, right?
Yes, that is correct.
Right, so your client goes, sees his employee at the hospital, and after leaving, I should fire him.
Well, we would submit that the one has nothing to do with the other, but
Really?
regardless,
Just coincidence,
yes,
just coincidence.
yes.
Okay.
Section 296, 1A says that the state is the employer. And in fact, that was a statutory amendment whereby before the amendment was enacted, there was ambiguity where I would say, Justice Manzanet Daniels, one could make the argument that you're making. We would submit that under New York State
I'm
human
not
rights
making an
law.
argument, I'm asking you questions. You're the one making arguments.
Yes, and I would say that one could say that that contention would have merit, but it doesn't anymore pursuant to the amendment that took effect in 2020 to the executive law.
Counsel,
Yes.
if I'm not mistaken, the argument of whether your client was an employer or not, that was really first raised in your reply papers below, right?
I would disagree with that because it was there on the face of the record.
Well, whether it's on the face of the record is not the issue. Did you make the argument in your initial brief? Is
The
question,
argument,
as you are required to.
the argument was made
First
with
raised in
full
your
force
reply
and-
paper.
with a greater force and effect in the reply papers, and we would submit this implicates subject matter jurisdiction. It can be raised at any time. And further, as was found in the case of Adolph versus Hill Kirby, Justice Kapnick was on the panel, there's a requirement on the part of the plaintiff to allege that the defendant is an employer and satisfies the requirements of the employer definition. There can be no satisfaction, for example, of the employer definition under the New York City human rights law because it isn't alleged anywhere. And that's what Adolph versus Hill Kirby stands for. There can be no satisfaction of the requirement that FMLA applies because it isn't alleged anywhere because it can't be that this assembly member employs at least 50 people in his state assembly office. And so put all of those together, combined with the fact that the acts of hiring, firing, supervising an employee, these are official capacity actions. And so at a minimum, under the Ajoku case, Justice Manzanet Daniels was on the panel in that case, New York State human rights law claims were allowed to proceed, but New York City human rights law claims were not. And the reason for that is that these are official acts, and the state cannot have its sovereign immunity abrogated by an enactment of the legislature, the council in New York City. And so at a minimum, there should be a dismissal of the New York City human rights law causes of action with respect to that immunity ground. And then we have the non-immunity based arguments. So first of all, with respect to disability discrimination, there needs to be a credible allegation that the plaintiff still would have been able to satisfy the requirements of the job. And this is established by the Romanello case in the New York Court of Appeals.
To tell us all about that.
Yes, absolutely. Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the Court. David Krause for the plaintiff respondent. This appeal is principally based on the notion that by virtue of his status as an elected official, appellant is absolutely immune from liability stemming from its intentional violations of the anti-discrimination and medical leave laws. A dangerous assertion antithetical to the idea that in a democracy such as ours, no one is above the law. Consistent with the overwhelming weight of the relevant authority, Supreme Court rightly rejected that argument. So too should this court. More generally, for the reasons stated in respondent's opposition brief, this court should affirm the trial court's denial of appellant's motion to dismiss in its entirety. I welcome your questions.
How about the concern about whether this is the appropriate forum, or not here, Supreme Court vis-a-vis Court of Claims? And I think maybe there was a concern too with the immunity in the distinction between the state human rights law claims on the one hand and the city human rights law claims on the other. You want to address that? That's actually two questions. So,
Sure, Your Honor. So both relate to the fact that these claims are brought against appellant in an individual capacity, as he is or was respondent's employer within the meaning of the New York City human rights law, which is expressly alleged in the complaint. And insofar as these claims are asserted against him in an individual capacity as an employer, they are properly venued in Supreme Court. The requirement that claims be brought in the Court of Claims only is so where two conditions are present. One, a claim arises from acts made in an official role, and two, the claim involves rights asserted not against the officer individually, but against the state. Here, of course, the claims, neither prong is satisfied insofar as the claims arise from acts made in an individual capacity as an employer, and because the claim involves rights asserted against appellant individually. After all, we have not asserted claims under the city human rights law against the state.
How do you support your third and fifth causes of action for aiding and abetting? How does Mr. Gibbs aid and abet his own discrimination?
Sure, I'm happy to address that, Your Honor. So those are effectively pled in the alternative, because we've also asserted claims against the state of New York for violation of the state human rights law. And surely he can be found liable as an aider and abetter of the New York State, rather the state's violations of the New York State human rights law.
Okay. All right. Thank you.
Thank you, Your Honors.
You got a minute.
Concerning the aiding and abetting, we would agree it isn't possible to aid and abet one's own discrimination. That's the Hardwick v. Oriema case from this court in 2014. And the only person who is alleged in the complaint to have done anything wrong is the Assemblymember Gibbs himself. And I would say it's not our argument that there's absolute immunity. Without question, if someone makes derogatory comments as an assembly member or otherwise.
That's not the only way to discriminate against someone, right? It's not just verbal comments. Sometimes conduct is discriminatory. And you know, if I am days away from getting my medical benefits at a job and my boss comes and sees me at the hospital and then terminates me, so now I'm in the hospital and I have no coverage.
Understood.
It certainly lends itself to an inference that this conduct was discriminatory.
And we recognize the complaint
the timing of it is horrendous.
All the allegations need to be accepted as true, but just because the complaint says it sues in an individual capacity doesn't make it so. One needs to look at the gravamen of the allegations, as was true in the Ajoku case, and we acknowledge in that case the state human rights law causes of action were allowed to proceed, but the city human rights law causes of action were not. And we would submit everything should be dismissed for all the reasons we set forth in our brief, but at a minimum,
the city ones.
The city ones need to be dismissed, and the FMLA statutory requirements aren't satisfied either, and I don't think there can be any legitimate dispute about that.
There's case law that says that someone who's about to get benefits, if they're terminated, they absolutely have a right, a cause of action. So we have case law in that regard.
Well,
but I hear you on the city. Thank you so much. Catan versus Roner. You may proceed.
Good afternoon, Mays Police and Court. My name is Andrew Walensky from Battalion Dunn for Plaintiff Appellant Ezra Catan. I've got 3 points that I can cover, of course, if the panel has questions. We can go in whatever order you'd like. The first one's the 327B issue. That statute strips the Supreme Court of the authority to dismiss this action on forum nonconvenience grounds. The second one relates to the City of Providence case, which this court decided.
But you know, that particular case, respectfully, is factually distinguishable from this case, particularly given our prior decision in 2024. That involved actions in New York, people in New York, whereas in your own pleadings and in your own argument, you recognize that almost all the directors, even if they have pied-à-terres here in New York, are all from Switzerland. Everything, all the harm, the dangers, not only took place in Switzerland, from your client's point of view, throughout the world, but certainly not New York. And recognizing that his claims, even if he has, if it involves ADRs, et cetera, that's not what he's complaining about. He's complaining about other investment interests here. So based on all the elements that Judge Maisley analyzed in her decision below, I don't see how you could possibly say your client case belongs here because he lives here, because that seems to be the only reason why we have this New York action.
Well, certainly there's a nexus between the client and New York, but in terms of the conduct itself, a significant amount of that did occur here. We talk about the Archegos issues, we talk about FX, we talk about a number of other...
So all of those issues were present in the Stevenson case, and in fact, the Stevenson case listed nearly 100 paragraphs from the complaint in this case, verbatim. And at the end, the Second Circuit dismisses that case based on forum nonconvenience. Why should this case be treated differently?
Well, the Second Circuit was applying the federal forum nonconvenience principles. First of all, we have the 327B argument, which I think does present a very strong basis to retain jurisdiction in New York. But in terms of the actual distinctions between this case and City of Providence, there's Archegos, which is the City of Providence. That's the core of that. This case includes that plus more. And when this court wrote in the City of Providence case that virtually every aspect of the subject matter underlying this action occurred in New York, the same is true of this case. We have a host of conduct that's pleaded in the complaint about whether it's DFS consent orders, whether it's the FIFA settlement. These are all items that occurred in New York that precipitated the Credit Suisse collapse in 2023. And I see that my time is running short, so I did want to get to the 327B issue. This is a mandatory provision in the statute. Shall not, the Supreme Court shall not stay or dismiss any action on forum nonconvenience grounds if the action arises out of or relates to a contract agreement, et cetera. And this certainly does relate to the conduct that we've the conduct at issue here.
How did your claims arise out of or relate to a contract agreement or undertaking to which General Obligations Law 5-1402 applies? The individual defendants are not parties to any agreement that's an issue here.
Yeah, that's right. But the conduct, the underlying conduct, the cause of action relates to that, whether it's the Archegos, whether it's the consent orders with the Department of Finance.
So is there an agreement here that you're relying upon which has a choice of New York law provision?
All of those agreements have Credit Suisse consenting to enforcement of those agreements in New York State. So
is that the same as a choice of New York law?
I mean, they're certainly subject to the Attorney General's enforcement authority. They're certainly subjected to
Well,
the
any
DFS.
business who does business here is subject to that.
That's right, Your Honor.
But that doesn't mean, that's not answering my colleague's question.
You didn't agree that this should be governed by New York law.
Well, I mean, they submitted to the
submitting to the jurisdiction, you may or may not have a choice, but that doesn't mean you are saying that this should be governed by New York law. Isn't this in fact governed by Swiss law?
Well, so that goes to the internal affairs issue, and yes, the substantive claims themselves are going to be governed by Swiss law, absolutely, and that's going to be the same
But
case.
don't you need that, doesn't this have to be governed, don't you need an agreement governed by New York law for this to fall under 327B, and you just don't have that here?
No, Your Honor, and GOL 5-1402 says, contains a provision or provisions whereby such foreign corporation or non-resident agrees to submit to the jurisdiction of the courts of the state. It's not, and that's exactly what has happened here.
You'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Jason Hall for the respondents. Respectfully, Your Honor, we think this is fairly straightforward. Justice Maisley conducted the analysis she needed to conduct under 327A, prong by prong, through the Pahlavi factors set forth. This case, very close analog to this case.
Why is this not a New York law governed agreement?
Your Honor, on the 327B issue, I think we would start a little further back in the causal chain. These claims don't arise from or relate to any of these agreements. They don't depend, the rights at issue don't depend. These are Swiss law fiduciary duty claims that could stand or fall totally
The
independent.
directors in Switzerland.
Correct. Correct, Your Honor. The plaintiff's allegation is that these are Swiss law claims. And I would say, Your Honor, and I think this is important, the plaintiff waived the 327B argument. It was never made in the motion to dismiss brief.
This was where the plaintiff asked if he could submit a surreply about 7 months after the motion was submitted. And I don't know if the judge didn't get to it or she denied it. And that never really was the focus of anything.
That's right, Your Honor. She did get to it. Before she decided the motion to dismiss, Justice Maisley ruled on the request for leave to submit a surreply, and her order was that the surreplies were procedurally improper. This was the second surreply that they had filed. This 327B argument was nowhere.
That wouldn't necessarily eliminate the possibility of them raising it here if it's regarded to be a legal issue as opposed to something which there might be factual disputes.
Well, that's right, Your Honor, or may be right. I will say that 327B was raised late again in the Houseman case that went to the Court of Appeals.
Well, we can all agree that it was raised late here. The question is whether it was raised too late.
That's right, Your Honor. If we get past the waiver issue, and I do think it was waived because Justice Maisley set forth a process for them to follow. In her March 2022 order, she said it was procedurally improper, and she told the plaintiff his remedy is to, quote, await a decision on the motion, and if appropriate, amend. The plaintiff didn't pursue that course that was spelled out by Justice Maisley. Instead, came to this court and is now arguing that they never had an opportunity and were denied an opportunity before Justice Maisley to raise this argument. They didn't do what she told them to do. Even if we get to the merits of the 327B argument, Your Honor, so Your Honor's correctly observed, none of these defendants, none of these individual defendants is a signatory to any of these agreements.
That's really not the basis of what this case is about.
It absolutely
the
is
claims
not.
in this case.
It's not a breach of contract claim arising from any of those contracts. This is a Swiss law breach of fiduciary duty claim that would rise or fall independent of these agreements. And if you look
Fundamentally, 327B, the purpose of it is to encourage parties to avail themselves of our very capable commercial expertise, particularly in our trial court. And to do that, we tell them, don't worry, if you put it in your contract, rest assured there won't be a form non-convenience dismissal.
If you put it in the contract, you're going to be bound by it, right? In other words, you can't be heard then to argue, well, I don't want to be in New York, I'd rather be somewhere else, even though I entered into a contract with a New York provision, New York foreign provision. That's not what's at issue here.
Are you aware of any authority, sir, that has considered the application of 327B to breach of fiduciary duty claims?
No, Your Honor. And I don't think the plaintiff points to any such authority. I don't think there is any such authority. unless there are further questions.
Thank you.
Thank you.
Thank you, Your Honors. I want to briefly get into the point that we were just talking about, which is when do we need to have a qualifying agreement, and what does that agreement look like? This is 327B does not only apply to breach of contract cases, and the notion that the statute only applies where the gravamen, that's the word that was used by my friends, is the breach of that agreement. That would render 327B just a nullity. A breach of contract claim arising from a New York law agreement.
Not in New York, it wouldn't be rendered a nullity.
Well, you'd have 327A, which would take care of that issue. If there was a contract and then it was breached and it has a New York law choice of agreement, then you look at 327A, and then you're home free on New York. But if we're looking at 327B, that has force only if it reaches actions that might otherwise be dismissed under subsection A's discretionary framework. And that is actions where the claims themselves are not for the breach of a qualifying agreement. And that's precisely what we're getting at here. And this falls into that exception to the 327A factors.
Thank you.
Thank you.
Hubschman versus 1010 Tenants Court.
May it please the court, Bruce Weiner for appellant Barbara Hubschman. The lower court dismissed 3 of the 6 causes of action here, even though the other 3 causes of action are really intertwined with the 3 that were dismissed, purely on the erroneous finding that Ms. Hubschman's rights with respect to her roof garden, which was constructed long before she bought the apartment and is part of the structure of the building, those rights had simply expired because the co-op and its attorneys came up with a pretext to allow the proprietary lease to expire so that they could enact a new proprietary lease that stripped her of all of her rights.
But Mr. Weiner, it seems to me that they had this meeting, this special meeting, they called it, before.
It wasn't they actually did it at an annual meeting, even though it was supposed to be done at a special meeting.
So they did it at the annual meeting before the proprietary lease actually expired.
Yes, but
so that was still in effect.
They didn't comply with the offering plan that says that the original proprietary lease would expire unless extended by a vote of the shareholders. They didn't give that opportunity to these shareholders.
So they didn't have a choice to say, oh, we vote to extend it or we
No,
don't.
they just said, we continue as a co-op, and here's your new lease. Vote on the new lease.
Because the original proprietary lease is extant, is still at the time, and she had certain rights under the original proprietary lease, particularly her right to consent to do certain kinds of release, et cetera. Therefore, the court below should not have dismissed the 4th cause of action. And because there was an attorney's fee provision in the original proprietary lease, your 6th cause of action should be reinstated as well based on 234 of the real property law.
In fact, it's the identical attorney's fees provision in the new lease. They didn't change that because it didn't affect Ms. Hubschman. They had been litigating with her since the 1980s, since Justice Donson had this case, and then Justice Gish before she...
Who you know I worked for many
Yes,
years ago.
many
so
years ago.
I
We all go back a long way here. Yes. So they pretextually claimed over and over again, and even decades later to Justice Gish, that the roof garden was causing leaks. And time and again,
And they pull it all up, and there was nothing wrong with the membrane.
correct.
Right.
And now they've changed the lease so they can make this claim again, except this time she has to pay for it.
And she can't insure it
Yeah.
because it's the building. It's not part of a shareholder's homeowner's policy. It can't be. It's
the lease
only
had
if she causes the damage.
If the lease had expired already, would you be able to seek any relief?
if the if the lease had already
If this
expired?
happened after the lease had
I
expired,
think so, but we didn't wait. We brought, a claim for a preliminary, temporary restraining order and preliminary injunction before the lease expired. But our position would be, Justice Friedman, that we would still have the right because this is part of the foundational
given to you
documents of the
before.
co-op. It emanates from the offering plan. And this court has said you have to read the offering plan and the proprietary lease together.
I think what you're trying to say is that you had a vested right in it.
She definitely had a vested right, and they couldn't change it with this pretext that some lawyer came up with to try and deprive her of her rights, which they couldn't do through 2 litigations, and then they enter into a
There's settlement agreement, right?
they enter into a settlement agreement, and now they're trying to say we can't enforce that, even though the Supreme Court retained jurisdiction to enforce it. Just because the lower court said, well, it refers to a proprietary lease that is no longer in effect. So it's
Who's your client?
92.
Thank you. You'll have time on rebuttal.
Thank you.
Devin Ness of Herrick Feinstein for respondents. Respectfully, Your Honors, the lower court properly determined that this case presents a simple question of contract law based on the expiration date.
We do too. We do too. Except that the proprietary lease had not expired when your clients attempted this little move of theirs.
The new lease did not take effect until after the expiration of the lease.
Yeah, but the vote happened during her lease still being in effect, which means you had to follow the contract language then in effect, and you didn't.
Respectfully, the
You
co-op
don't have to
did.
say respectfully. We know what that means. Go ahead.
Thank you, Your Honor. The co-op followed the letter of the bylaws and the letter of the lease. They did not change this lease.
My understanding is that the original offering plan and the original lease trumps the bylaws. We know that, right?
I disagree with that interpretation. The original offering plan comes into play when the terms of the lease and the terms of the bylaws or
No, the case
certificate of
law
incorporation.
is, we have replete case law that says again and again and again that you have to consider all of those documents together.
When there's an ambiguity.
No.
Yes, all of those cases relate to instances in which the terms of the proprietary lease itself do not clearly determine the issue. They all relate to instances such as the identity of the holders of unsold shares, because the holder of unsold shares is an issue that's not determined by the proprietary lease and therefore has to be determined by reference to the offering plan.
Why isn't there a breach of contract cause of action based upon paragraph 7 of the proprietary lease, which gave for these, in conjunction with paragraph 6, which gave for these continuing rights? I mean, she moves before the lease expires. You are arguably, and this is a pleading motion, you've arguably violated that. So why isn't there a breach of contract cause of action that should stand up?
Because the terms of paragraph 7 of the lease are subject to the expiration date of the lease. And so
But they move before it expires.
But they didn't move to change the lease. They moved to adopt a new lease upon the expiration of the other lease. So they didn't, if they had adopted a lease at the vote commencing immediately, that would be changing the lease during the term of the lease. What they did was they adopted a new lease to take effect
But you are
following
ignoring
the
the
expiration.
fact that at the time you take the action, that's the relevant time period. You can't say, we're going to take this action today, but it's not going to go into effect until after your stuff is expired so that we're okay. No, you have to do it when that lease is no longer in effect, because you are subject to the terms of that lease while it is in effect.
Parties all the time can negotiate a subsequent agreement.
Yeah, but that agreement provides you can't act without her consent.
I'm sorry, I couldn't hear you.
That paragraph 7 provides you can't act without her consent. So perhaps even going forward, you have to live up to that. And to the extent that maybe you don't, they moved before the lease expired.
They didn't change the lease until after, they didn't adopt the new lease until after.
Didn't she have a continuing right on that you can't take away what she had under paragraph 7 without her consent?
Yes, but that right expired in September of
Yeah,
2020.
but you took the action before it expired, even though you said it wasn't going to go in effect. I mean, that's kind of a run around what the statutes, I mean, what the lease
The
says.
terms of the bylaws say that they could vote to continue it had to be prior to 30 days after the expiration of the lease. So they took under,
I think you guys tried to outsmart yourselves, and it's backfiring.
I think the terms of the lease are clear.
Yes, I think the terms of the lease are real clear. That's the point.
There are no indefinite rights granted under leases in New York law.
Okay.
Thank you, Your Honors.
Unless the court has any questions.
I think what he's saying is that, yeah, you've got all these rights, that's great, but once the lease expires, you have nothing, and therefore you can come after us.
The answer to that, Justice Friedman, is that as long as the co-op remains in effect, those rights continue. The co-op could be terminated by a vote of the shareholders. They said, no, we don't want to terminate. And what every other co-op in the city does is they adopt a simple extension agreement that's a 1 or 2 page agreement. That's not what they were out
And
to.
at this meeting, if I recall correctly, this 92-year-old woman was not allowed to speak and say her piece.
And her son.
In front of the shareholders
son, who
or
was
her
present.
son, right?
Yes.
So they trampling all over her rights.
They didn't even give her the notice.
And she doesn't get to say a word.
She didn't even get the notice. She found out from a neighbor, because I think that they were intending for her not to even show up and know what was going on. Thank you.
People versus Devon Pleasant.
Good afternoon, Your
Good
Honors.
afternoon.
David Clem for Appellant Devon Pleasant. I think the issue in the case is fairly limited because of how it comes to us, and that it's limited to whether an Erlanger claim, regardless of its underlying merits, can first be pursued in a CPL 44020 motion. And frankly, the Court of Appeals has answered that. It clearly can be. You could.
Yeah, but don't we have to step back a second? When you're asked whether you're challenging the second felony offender statement, you have no challenge. You never make any challenge to any of this. You accept what the people allege. Doesn't that end the issue? How do we get to Erlanger when you haven't created an issue about it?
And I mean, here, if I might add to that, please correct me if I've confused the cases, okay? But didn't the defense lawyer here say, no, I checked myself and I've done the computations, there's no problem?
So let me take those separately.
Okay.
As to Justice Friedman's question, I think the Juergens case from the Court of Appeals plainly answered that. The same circumstances were present in Juergens, a challenge to a predicate, and the Court of Appeals said very clearly, and I quote them, the proper vehicle for raising a challenge to a sentence as illegal in terms of the predicate is through a CPL 44020 motion. Raising the predicate felony issue in a CPL 44020 motion serves the, quote, goals and purposes of the preservation rule. So it can be done in the first instance through a 44020
It can be done, but it doesn't mean you can win it.
That's true. So, but in terms of the preservation,
Putting
which was
aside the fact that you know where I stand on the Erlanger issue, but putting that aside, I mean, but even not considering that, I mean, yeah, so you can bring the challenge. This is the appropriate vehicle to try to preserve the defendant's rights if ultimately Erlanger is given effect in New York. But for this case, as the law stands now, you waived it, unless this court or the Court of Appeals says that Erlanger applies.
Yeah, so that brings up to the question of waiver. So just putting aside, the lower court was clearly wrong in saying this wasn't preserved. The 44020 motion preserved it. So the question is, was it waived?
Well, clearly in the allocution, both even after the second plea, the first plea, the second plea, on page 20, the court made it very clear to prior counsel, you reviewed your client concept of tolling. Nobody challenged the prior felony conviction in 2008. Nobody challenged the calculations.
The waiver question, though, we're talking about a waiver of the constitutional right for a jury to determine tolling. And so the standard is whether that's a knowing, intelligent, and voluntary waiver of your Fifth and Sixth Amendment rights. I don't think there's any plausible reading of this record that could show that that's a knowing and voluntary waiver of that constitutional right, a right which this court has already said doesn't actually exist. There is no right to have or there is no mechanism to have a jury determine tolling. So I don't understand how that right could be knowingly waived by Mr. Pleasant. Certainly the...
If you say what the people say is correct, so that's how it could be knowingly waived. There's no factual, we don't need a jury to decide something which there's no factual dispute about.
So let me get to that issue. First, I don't believe that anything at that first predicate arraignment could possibly be relevant or used here. That plea was vacated and rendered nugatory. Regardless, the Court of Appeals...
They repeated later on in the second round.
They repeated some of it. There was no mention of tolling in the predicate adjudication that is at issue here. But let me point out what the Court of Appeals said in Wright, which postdates this court's Gomez and Stanton decisions. The Court of Appeals said this is a right personal to the defendant, and that defense counsel, even saying, yes, tolling's correct, I've gone over it, it's all accurate, which is what happened in the Wright case, cannot waive it for the defendant.
I think it's Gomez. Would that support the view that even if there was some error made here, that the error would be harmless error because of the factual context of this case?
It would be hard in this case to find that it's harmless. There's 3 separate predicate statements. They changed the number of dates. They're 31 days. Their last one's only 31 days over that. It differs by 3 months from the one before. It changes the places of incarceration. There's no basis on which to say that we could be confident what the dates of incarceration are and the types of incarceration. So I don't think there's any basis to find it's harmless. Certainly the court below didn't, which all goes to the remedy question. Unfortunately, I don't think the court can get to the harmlessness or the merits here. I think the only appropriate remedy is to send it back to the court because its ruling on, which was really only on preservation, is clearly wrong, and even to the extent it was on waiver, is incorrect.
You're saying we should send it back so that the court can consider it on the merits since the court was incorrect in its assessment?
I think that's what this court said in Goldfaden in looking at the Concepcion line of cases that the court doesn't have jurisdiction to otherwise consider claims that weren't ruled upon by the
There's a
trial court.
LaFontaine problem.
Exactly.
Okay.
Thank you. Counsel?
Good afternoon, Your Honors. If it please the court, Kate Gerfon for respondent. So
I just want to pick up on one. I know it's not the major point of the appeal, but under Gomez, would there be anything inappropriate about saying that harmless error analysis could apply here?
no, Your Honor, and I was just going to, you read my mind. Under Gomez, so, and this is similar here, right? Because it was a consolidated 440 and there was no preservation, there was no challenge to the predicate statement below. Because there was no challenge, and because of the defendant never moved to controvert in Gomez, as he did not do here either, the court, this court, said there could have been harmless error. With our case, that holds true, and in addition to that, there was, any error was harmless.
You say there's no error. I understand that.
Thank you, thank you. It's been a long afternoon. Any error would have been harmless in this case specifically because the defendant, even if you put aside his predicate sentence, so let's say he was not sentenced as a predicate, he only got, he with a D-violent non-predicate, he stood exposed to 2 to 7 years. He was only sentenced to 5. So he was sentenced essentially as a non-predicate because of the replead, because he violated the condition and then he was allowed to replead. So as with Gomez, as with Stanton, there was no challenge. He waived. He did not challenge the predicate statement. In fact, the facts here are stronger than they were in Gomez and Stanton because he twice waived. To my adversary's point, the first allocution, if you will, counsel was much more vocal and explicitly said, I reviewed the tolling, I concede. The second time around, while counsel admittedly did not have as much to say, defendant himself said, I've reviewed it, I've talked to my lawyer, I looked at the form, and the defendant, as to my adversary's point with Wright, what the Court of Appeals held in Wright is that the defendant essentially is in the best position, and to controvert is very personal to the defendant because the defendant knows what his incarceratory time was. So here, the defendant was in the best position, regardless of any discrepancy in one predicate statement to the next, and they both made out the allotted time, which has not been challenged. The defendant knew what his incarceratory periods were, and he waived them. And then, if there are no further questions on that, I just want to make one point. I do want to correct a representation that my adversary made in his reply brief. We did not concede that this matter was not preserved. While we did not spill as much ink on a preservation argument as we did on our waiver, we did say that a 44020 is not the proper vehicle because this is not an illegal sentence claim. This is a constitutional challenge to a statute that was not made at the time of sentencing. This is an Apprendi claim, and Juergens and and its progeny have held a constitutional challenge, and Apprendi claim must be preserved below. And if no further questions, we rest on our brief. Thank you.
I'm going to give you her extra time since she didn't use all of hers.
Thank you. As to the waiver standard, again, I just want to emphasize this is a waiver of a jury trial right. We would never consider that a defendant is knowingly, intelligently waiving their right to a jury trial because the court just decides to sentence someone without a jury and the defendant doesn't object. That's just inconceivable to us. What we require is there be questions about it. And I think this U.S. Supreme Court has spoken about this most clearly in a case called Dominique Benitez, which I cite in my reply brief, where the court said that the record must show that there's evidence that the defendant knew of the rights he was putatively waiving. I don't understand how that standard could possibly be met here. There is no claim that Mr. Pleasant understood that he had a right to a jury to determine the question of tolling. So I don't think this falls under waiver either. I think the only appropriate remedy is to send it back for the determination of the merits of the Erlanger claim. Thank you.
Zayobro versus Milan House.
Good afternoon, Your Honors, if it may please the court. Jordan Jodre of Jodre Bernecki for the appellants. We contend that there exist innumerable questions of fact pertaining to the subject incident that precludes a finding of summary judgment as to the Supreme Court's decision regarding plaintiff's labor law 200 and 241 claims. As the court is well aware, the purpose in deciding a motion for summary judgment is issue finding, not issue determination. It is here where the Supreme Court decision erred. Further, the Supreme Court simply omitted properly submitted evidence and assumed facts that were not in evidence in reaching its decision. Defendant's brief repeatedly says that our arguments are contrived, but they are not. The arguments were specifically stated and cited to on the record. And these are the same facts and statements and testimony that were unfortunately overlooked by the lower court in making its decision. Specifically, as to the first instance, there was an error pursuant to CPOR 2214C. Pursuant to 2214C, we can cite back to other documents that have already been submitted. The Supreme Court...
You only have 5 minutes.
Yes.
Do you want to spend your time talking about procedural stuff, or you want to get to the heart of the issue?
Your Honor, I appreciate that. Thank you.
Time.
Thank you very much. No, I understand that. Specifically, it is our contention that, as this court is well aware, there's more than one proximate cause to an accident. Our client stated that he slipped and fell on debris, but he also slipped and fell on water. Water that was present on the staircase and present within the subject location throughout the removal of the debris that he was hired to remove. Now, the manner and method by which the debris was removed was determined by the defendants. They had to use a specific door, a specific staircase. They had to go through specific gates. They had to go through a courtyard.
The chain reaction, so to speak, in taking the debris in bags, et cetera, was all controlled by that.
Absolutely, Your Honor.
And of course, under the circumstances, given that these bags weren't the kind of bags we're supposed to buy that are flexible, whatever, the debris was not necessarily integral to the work. Someone had to clean it up.
Well, yes, I understand.
So Basdarac would control here, arguably.
Thank you.
At least to create an issue of fact.
And that's exactly what I was going to bring up. Basdarac certainly controls with regard to means and methods. There was nothing that couldn't have been done in order to lessen the potential for...
The debris in question on the staircase that wasn't being picked up from that staircase, correct?
Well, no, yes.
It was debris that was being hauled from the work area and being thrown out to a waiting truck.
Yes, Your Honor.
So time was of the essence for these workers.
Absolutely, Your Honor.
I guess the truck was waiting and they all knew that they had to hurry up and get this done, right?
Yes, a supervisor had brought the truck or the van, and
now,
it was sitting.
now do it.
Yes, and it was literally sitting outside.
Right.
And there were more than 50 bags of debris that had to be moved from a co-op that comprised 2 buildings. The elevators and the gates and the courtyard, which was open to the environment, had to be traversed multiple times in order to move these bags. Accordingly, I think that as Your Honor put forward, Basdarac does apply here because there were many other methods by which they could have alleviated the condition that created the subject incident with regard to the debris on the stairs, with regard to the ice and water on the stairs, which my client repeatedly attested to during multiple depositions. If there's no further questions, I'll cede my reply. Thank you.
May it please the court, Glenn Kaminsky with the firm Morrow, Lilling, the party counsel for the respondents. And I would ask this court respectfully to affirm the very well-reasoned decision of Justice Chan. Plaintiff's argument on appeal are completely belied by the testimony of his client. The Supreme Court properly ruled that what caused the plaintiff's injuries was the debris falling from the bags that he was moving at the time. The respondents demonstrated that they had no control over the means and methods of the work, and there was not. There could not be any notice of a dangerous condition of this debris. The plaintiff testified it was occurring as it was happening, and even at his best, at 701, 702 of the record, he says, after 10 to 15 minutes after they moved the bags down, the accident happened. That's the notice period at its best. That can't be constructive.
Means and methods doesn't require notice. Means and methods is like cause and create it. So if they're controlling how the plaintiff was removing the bags, which allowed for cheap bags that allowed this heavy debris to break through and cause the trip hazard that occurred here, you don't need notice.
The building
You're
defendants
causing
didn't
it.
give him the bags. The building defendants didn't give him the bags. That's the means and methods of the employer. That's not our means and methods. They're not our bags. We didn't give it to them. We just told them, you got to use the service elevator, the service staircase, like every other building in the city of New York, because that protects the residents of those buildings. It protects the workers from having to be.
Protect this worker.
The stairs didn't cause the accident, Your Honor. Respectfully, he tripped over the very debris he was assigned to move. It was integral to the work, whether you look at it.
No, it wasn't. Integral to the work? Nope.
Oh,
That's not how this gets applied.
I missed, counsel, I apologize. I misspoke. I wasn't focused on the 200. I understand that part. But under 241.6, you're on the hook. It's strict liability. You're on the food chain. And if it's not integral to the work, I misspoke. If it's not integral to the work, then you're on the hook, correct?
If it's not integral to the work, then under
And under
23.1.7.
under Basdaric, this wouldn't be integral to the work, right?
I would disagree with that, because in
I was on
Basdaric,
Basdaric. I'm telling you. Here, the garbage, the work was being done on another floor. This was garbage being thrown out from another floor. It was integral to the work on that floor. Once you start transporting garbage, it's not integral to the work. Now the work is throw out the garbage.
well, respectfully, that's all part of it. How does the garbage just stay in the apartment? It has to be moved. In
It has to be moved
Basdaric,
safely.
in Basdaric, again, that's the employer's problem. In Basdaric, they laid down a slippery substance on the escalator.
They laid down plastic, and because they were more concerned with the escalator getting paint than with their workers slipping down the escalator on plastic. That's what happened in Basdaric.
So they put a slippery substance down. So that substance wasn't integral to the work, but under Bond, that we cited page 25 of our brief, under Mirolo, which we cited page 25 and 26 of our brief, debris is an inherent part of demolition. It is part of it.
Were they involved in demolition at the time of this fall? No.
Yes, because...
No, they were not. They were throwing out garbage. Counsel, you cannot... Counsel, they were not... For you to suggest that they were involved in demolition at the time of this accident is the most disingenuous argument you can make. They were walking upstairs throwing out garbage. Demolition had already happened. So you cannot make that argument on these facts.
I
cannot.
respectfully disagree, because you have to remove the demolition from the
That
building.
doesn't make it demolition. Removal of demolition debris is not demolition.
I think it's almost we're getting into like the panic situation where
Counsel,
where you have...
Are we gonna go back and forth in an argument?
Well,
I'm telling you, okay? Demolition removal of debris is not demolition. And I'd love for you to cite a case that says that demolition, removal of debris equals demolition.
I think Murillo and Bond are on point.
Okay. You have a minute.
If there are no further questions from your honors, we'll rest on our papers.
Thank you.
Thank you, Your Honor.
Gant versus City of New York. No, they made it hot. Yeah.
Good afternoon, Your Honors. Teresa Frame from the MTA Law Department on behalf of the bus defendants appellants in this matter. This matter concerns an accident that occurred while a bus was overtaking a truck that appeared to be double parked. The evidence submitted on the defendant's dueling motions for summary judgment established that the sole proximate cause of the accident
you can't say sole proximate cause on this fact pattern. A bus decides to go into the opposite lane to go around a huge truck that is clearly backing up or in the process of parking. There's no question. Your own witness says she could see that he's in the process of parking.
I would disagree that our witness said that he was in the process of parking. Our witness...
At the moment he had stopped, another car went around this vehicle, right? That's what the record shows. Another car in front of her does exactly the same thing, goes into the oncoming lane of traffic and goes around this car that is still in the process. It's a tow truck. It's not a regular little car. It's a tow truck trying to back into a space. Story Avenue has only one lane of traffic in each direction.
May I
Yes?
address that? Our bus operator testified that she saw this truck was stopped. And the bus video clearly portrays that there is no brake lights illuminated on this truck, indicating that it is parked. It is not
I mean,
in the process of moving.
It was, if you look at it, it wasn't parked in the spot. The guy was still parking it. I mean, he was sticking into the lane. It wasn't parked in the parking spot at that point. It was in the process of parking. You have to maneuver. Not sure if you drive, but you have to maneuver to get into a spot. I can't imagine maneuvering a tow truck to get into a spot. While he was doing that, you know, everybody has to be careful of what's going on. I'm not saying they're free from guilt, but I don't see how.
The bus operator did not observe any signs that the truck would move. The truck appeared to be completely parked because it didn't have brake lights on. It didn't have any other indications that it was in the process of moving. So there were no turn signals illuminated. It just
Brake
looked.
lights would only be on if you have your foot on the brake, right?
That's correct, Your Honor, but the truck was also not moving in any way.
The truck was also not perpendicular to the street. It was
Yes.
on an angle, which signifies to anyone who drives that the vehicle was in the process of parking. Look, sometimes, and especially with a big vehicle, when you are backing into you have to stop, correct the wheel, keep moving. It's the process of driving.
Yes, however, at that
Someone
time,
who drives a bus should know that.
the brake lights are illuminated when that happens, showing that you are stopped, you are moving.
What do you seek to have happen as a result of your appeal? What is it that you're asking us to do today with this case?
You're asking that we be granted summary judgment on the issue of liability in the alternative.
That you be let out of the case?
That's correct, Your Honor.
And what about the trucking company?
The trucking company stays in,
Mm-hmm.
so we're reversing that determination by.
Well, if you're let out, you don't care what happens to the trucking company,
Excuse me.
right?
Right.
But you want to be let out, and the corollary of that, I suppose, is that they should be kept in. But why isn't what should happen here that both of you should be in?
In that case, we would ask that our motion be remanded for consideration of the threshold arguments that we made. I do want to bring the court back to the proximate cause issue and just point out this court's decision in Santana Lizardo versus New York City Transit Authority. As our appellant brief went through, it's an analogous situation. Of course, your honors have indicated that the positioning of the truck is a distinction here, and we agree with that. However, the analogous fact there is that in Santana Lizardo, the left turn signal was illuminated by the car that the bus was passing. So in that case, you could have inferred that the car was going to move. Here, there's even less indication of that. There's no brake lights illuminated, there's no turn signals.
You know, the video doesn't show that.
It's undisputed, Your Honor.
And in the case that you're referring.
Who says, wait a minute, what's undisputed?
That there were no turn signals engaged or brake lights illuminated.
How would the plaintiff, how would the truck driver know what the bus driver could see in the vehicle behind him?
I don't think the truck driver could know what was seen by the bus operator, but we're going back to an issue that isn't
Saying
part
the
of this
truck
appeal.
driver said, because he says he's parking and he has to move forward, go back forward in order to finish his parking, right? So that to me means he's going back, stopping, going forward, back, etc., the way one parks.
Yes, Your Honor.
Right?
The undisputed fact is that the brake lights were not illuminated because they were actually defective, and that's a separate issue that was addressed below but was not included in the briefs because it's just a corollary issue.
I didn't.
Yeah, I understand.
I was like, where's that coming from?
I understand. Thank you,
Okay.
Your Honors.
Thank you for that. All right.
Good morning, Your Honors. May it please the court.
Good afternoon.
Good afternoon.
Better. I hope
You've been
it's
here a
not
long
still the
time.
morning.
Well, why isn't what should happen here that both of you belong in the case?
I mean, the whole case rests on the actions of the bus. We would argue that they are the proximate cause of this. Whether or not the truck was stopped or not stopped, the bus came upon our truck, saw that we were on it, had a clear...
Except your client admits that he saw the bus. So if he cannot complete his parking maneuver, and I could understand why in light of the size of his vehicle, if he can't manipulate his vehicle to complete the park into the lane, right? And he has to move back into traffic. He knows that bus is coming. No signal, nothing. He doesn't even look.
He had stopped his vehicle.
He admits he didn't look. He saw a bus coming behind him.
But as the bus approaches him, they have the duty to stop. They can see him.
he
for a
doesn't
period
have
of
the
admit that he
time.
moved
He had-
also?
he had already-
Doesn't he admit, isn't there evidence that the truck also moved? You're both in motion, and therefore you both belong in the case.
Exactly.
We would argue that that's
I'm
not
not
true,
saying
that-
I'm not saying it is a matter of fact. I'm saying that there's an issue of fact. There's a view of the facts here which has you both in motion, and if there is such a view of it, you both belong in the case.
even arguing whether if we agree that the truck had moved, that may create a duty on the
Your
driver.
client
that does
says
not,
so.
But that does not.
If
that-
your client says he moved forward, and that's when the collision occurs. So look.
When the bus crews began their actions,
I don't disagree with you that I don't think it's the smartest thing for a bus to go around a car that's trying to park, especially a car of this size. A truck of this size. I don't disagree with you. But your client says he sees the bus. The bus hasn't passed him, but he moves back into the lane without looking. How is that not both of you have some both of these drivers have negligence here? And let the jury decide. As your adversary said, send it back so the court can decide those portions of the motion that were not decided.
well, my adversary asks for only the threshold motions to be decided. She's asking for summary judgment.
No, I recognize that, but I think based on what I've just said, clearly it seems to me there's an issue of fact on liability, and I could see a jury determining that both drivers here were at fault and apportioning liability between the two of you.
There's also the possibility that on remand, if we rule that way, that they will not be successful in determining serious injuries here. And in which case, no plaintiffs, no damages, no case.
That's correct. I mean, I don't think that this case is one in which causation will be right for the jury based upon the
Oh,
bus
yeah,
driver's
it would have to be the
As
threshold.
they
motion.
violated, their actions were negligence per se. They violated the statutory laws.
So was
Truck
yours.
did not.
I'm sorry. Your client pulls out a truck into a lane knowing there's a bus coming and doesn't look. That's negligence.
Their actions.
And it'll be up to a jury to decide how much each of them apportion.
Didn't your client testify that he assumed the bus would stop? You made an assumption, right?
Yeah.
He had began maneuvering into the spot before
but
the
but
bus
he
had rounded the
testified
corner.
to that.
And as he was attempting to parallel park, had presupposed that a bus of that size, because he's angled on the Story, the way that he's angled in the street, blocking the street as Story Avenue is only one lane, that a bus driver who is highly trained would have stopped to allow him to complete his parking.
Ultimately, doesn't all of this boil down to reasonableness? The reasonableness under the circumstances with respect to the actions or inactions of both drivers. And so there may be certain, one or both drivers may have violated one or more VTL provisions, which would create negligence per se, but ultimately it is, particularly for apportionment purposes, would be reasonableness. And was your driver reasonable under the circumstances in moving that vehicle at the moment he did? Maybe he was, maybe he wasn't.
I think the only determination of reasonableness is on the city, the bus.
All right. Thank you.
Thank you.
You have 1 minute.
Thank you, Your Honors. Going back to proximate cause, our position is that once the bus entered the lane of oncoming traffic successfully, it was then the duty of the truck driver to make sure the lane was clear before he then entered it, which was also
Wait a minute. Your truck driver wasn't in the lane successfully. Your truck driver was in the opposite oncoming lane.
That's correct.
Okay, so, counsel, a bus, a city bus, goes around a parking vehicle onto oncoming traffic and collides with that vehicle.
Your Honor, I would not be making this argument had the brake lights been engaged and had this court not decided Santana Lizardo. I believe we have a meritorious position, and I'll rest on my briefs. Thank you.
People versus Joshua Bosch, last but not least. What time is it?
It's still afternoon, Your Honor.
Okay.
I think we'll be done before 5 p.m.
All right.
So, good afternoon from Mr. Joshua Bosch, Office of Appellate Defender by Christiana Preacher Lee. A truly modest 6-month reduction is appropriate here to 4.5 years. The parties agreed that Mr. Bosch's offense, which played out over the course of 36 hours, was motivated by substances and his mental health issues, including diagnoses of PTSD, bipolar, and schizophrenia, and was evidenced by him being hospitalized not once, but twice over the course of this incident, including for an instance of self-harm where he fractured his own nose. Recognizing his mental health struggles, the prosecution offered a lower plea here of 3 years if he attempted treatment but was unsuccessful. And where this was Mr. Bosch's first opportunity in the course of all of his struggles over a decade plus of mental
Michonne
illness.
tried very hard to have a treatment resolution of this case, and he put him into treatment. They didn't even, there were some problems at the beginning while he was in the treatment program, but it was only at the end, you know, he's smoking K2 cigarettes in bed 3 times. The treatment program says we just can't continue with him. I mean, it was really a tremendous effort here to come to a non-incarceratory resolution. It's sort of the defendant just left no choice.
And that's exactly what we want this court to look at, that the parties were trying to come to a non-custodial solution. They did on multiple occasions. The first plea deal that they came to said that if Mr. Bosch attempted treatment, but had a relapse, had some reason that he was unable to complete treatment, which is what happened here, he would be sentenced to three years of incarceration. And so here, Mr. Bosch tried for 7 months. He was complying with all of the terms. He had a couple minor behavioral infractions for eating a Jolly Rancher that he wasn't supposed to. And
So they didn't throw him out because of that?
No, they threw him out for relapsing, which is a natural part of the recovery process. He smoked K2.
They threw him out because he was smoking in bed.
Yes, he was smoking in bed. He fell down. He is someone who suffered for decades from severe struggles with substance use, and he was trying to get better. And he apologized to the court. The court expressed that it was sorry that it had to sentence him to the 5 years on the plea deal. And we're asking this court to consider these circumstances, consider that relapse is a natural part of the recovery process, and where Mr. Bosch has already served over 4 years, we're simply asking this court to reduce by 6 months so he can return home.
So you don't have a problem with the colloquy then?
Your
I mean,
Honor,
it sounds like you're making an interested justice argument, which is fair, and we're okay with the colloquy, so we have a knowing waiver.
the waiver of the right of appeal?
Yeah.
Yes, there's numerous issues with that waiver of the right of appeal. I'm happy to get into it now or wait for my time on rebuttal. But we would focus this court on the fact that originally that written plea agreement that he signed, that mentioned only that he was waiving his appeal of his speedy trial issues. It mentioned nothing about his excessiveness of his sentence. And so Mr. Bosch went into this appearance not knowing that he was going to be waiving this appellate rights. And then
In Judge Marchand's colloquy, he mentions that the waiver waives his excessive sentence. He explicitly mentions the waiver of the excessive sentencing claim, I thought.
eventually he does, but the order in which that colloquy played out would have confused anyone, especially Mr. Bosch with his mental health issues. The court asked him to admit to his guilt. Then the court went into the oral colloquy, which was basically half of the model colloquy. It was missing important aspects. And during that, he did say excessive sentence. But afterwards, the court went into the plea agreement here. And that's the first time on the record it was mentioned that if he did not complete treatment, he would be sentenced to these 5 years. And so under the Maracle line of cases, the court has a continuing obligation to ensure he knows what rights he's waiving. And it's our position that at that point, the court was under the obligation to ensure that he knew what he was waiving here.
We'll have time on rebuttal.
Good afternoon. May it please the court. Margaret Crookston for the people. Just briefly, a point of clarification. This waiver was valid. Twice during the colloquy, the court said specifically that excessive sentences would be barred by this waiver. When they arrived for the plea hearing, counsel specifically said, I have the waiver, I have the plea agreement, I've discussed it with my client, we're ready to move forward with the plea agreement that the prosecutor and the court has put together. Then the court went through with that, went through the colloquy, told him of the trial rights he was going to be giving up, and then said, ordinarily you will retain your right to appeal even with a guilty plea, but as a condition of this plea agreement, you are waiving your right to appeal, explained that he would have the right to attorney on appeal. He said multiple times, do you understand? He said the appeal waiver covered most kinds of claims. And then afterwards, he verified that the defendant signed the written waiver in open court, which reiterated all of these things, that it's separate and distinct, and that some claims survived it. I think briefly just to distinguish between Maracle, in that case, the defendant was told that if they came up with half of the restitution before sentencing, they would be sentenced to 5 years probation, but if not, the judge didn't have to abide by that sentence. The actual sentence that would be imposed was never mentioned, and it was only at the sentencing hearing that was the first time that the court informed the defendant in Maracle that they would be receiving the maximum incarceratory term on the entire indictment. So I think that's very distinguishable here, where they had the agreement which specifically stated it would be 5 years incarceration, 5 years PSR. They came to that court with that understanding, and that is the sentence. It's not an enhanced sentence. It is the sentence at the plea agreement. He said, I'm sentencing you to this 5 years and 5 years, but we aren't going to impose it yet to give you the opportunity. And they did give him the opportunity, and as it was noted, they were trying to work with him, trying to give him this chance, and it was a progression of escalating infractions with the behavior and inability to follow the rules of the program, and then ultimately his usage of K2.
Can you remind me how long he was in the treatment program?
I believe he was from November to August. I know August 7th, 2023 was when he was discharged, or when the court was notified that he was discharged, and I believe, and my friend can correct me if I'm wrong, that it was November.
Thank you.
Thank you.
Thank you.
Yes, respondent is correct that he was in treatment for almost 9 months. It was only after the 8th month that he had the relapse.
And in order to have successfully completed the program, was there a certain amount of time that he needed to stay in that program?
Not under this agreement. It was the mental health court, so it was whenever the court decided that he was successfully completed.
Okay.
But I would note under the first plea agreement that was in the file, after 6 months of treatment under that agreement, he would have been released to a conditional discharge. As to the appeal waiver, the Maracle line of cases is all about ensuring that there is continuing consent to the terms of what is being waived, and that was not done here with the order of how everything played out. The written waiver that the respondent mentioned, it was not at any point the court did not confirm that he read that written waiver, spoke to his counsel about that written waiver, or confirmed that he understood that written waiver. And so under these circumstances where Mr. Bosk has already served more than 4 years, we'd ask that he be allowed to return home.
Thank you.